May it please, my lord.
Yes.
Lordship, I may be allowed to make a mention for item 5, Lordship. If this can be taken up after 4 weeks, Lordship.
Why?
Because, Lordship, a similar item, which has been a similar case which has been allowed by this division bench, Lordship, arising out of the same department, an SLP has been preferred by the state in the Supreme Court, Lordship, which is pending.
Do you have the number?
The SLP number, no, Lordship, but the case diary number we have, Lordship. The case number, diary number is 22747/2024.
22747.
Yes, my lord. 747/2024, Roman 14 in capital. After that, Roman 14 in capital.
What is that Roman 14?
I don't know, but that is the number that they have given, Lordship. The Supreme Court has sent to the Lok Adalat for resolving the issue between the petitioner and the state, Lordship, but the state was not willing to amicably resolve the issue. So I believe the SLB will go ahead.
But you only have a diary number.
Yes,
It has
Lordship.
not been registered as such.
Yes, my lord.
Yes, what do you say, Mr. Akbar?
No objection, my lord.
Okay. Mr. Sentianger, learned counsel for the appellant, submits that a similar matter is pending before the Apex Court. The same being registered under diary number 22747/2024. Then Roman 14. And therefore, the outcome of the same may be awaited, as it will cover the present matter as well. Stop. Mr. E. Tivapo, London State Counsel. You are there also?
For respondent number 5,
And Miss
Monbeni Izung. Monbeni Izung,
Monbene Ezung, Learned Counsel for respondent number
5.
5. Agrees to the submission and have no objection. In view of above, matter stands adjourned for 4 weeks.
5 weeks, Lordship.
We inform the court.
My lord, my
4
lord.
weeks at the time, 4 weeks. Parties may inform the status of the case before the apex court by the next court date. Make it 6 weeks then,
My lord,
6 weeks. All right.
much obliged.
May I please, Your Lordship? My lord, I beg to mention item number 7 and 8. My lord, here I'm yet to receive instruction. So kindly allow me 2 weeks time, my lord.
7 and 8 are clubbed together.
Yes, my lord.
Huh?
Yes, my lord.
The cost list doesn't say so. These are separate cases. They're not clubbed together.
So a similar prayer for item number 8 or something.
May it please your lordships, lordship, this is a habeas corpus petition. And time has been given to the government. Therefore, my lord, may kindly hear me.
This is the second time it's
Second-
coming up. What is the status of the notice?
My lord, the special secretary, she was out of station. So she will be reaching this week. So next week, I'll get the instruction, my lord.
Anyway, we let the matter reach, we'll see.
Yes, ma'am.
Let the matter reach. Okay.
Much.
May I please, the lordships?
Yes.
Lordships, I beg to mention hearing item number 19 to 21, lordship. Lordship, I'm for respondent number 4. lordship. The matter has been recently endorsed to me, lordship, and the brief is not with me, lordship. So if this matter can come up after a week.
Who's for the other side?
Lordship, I'm for the petitioner, Lordship, in item number 19, Lordship, local council, Lordship.
Any objection?
No, Lordship.
Okay. Mr. V. Zimomi, Learned State Counsel, appearing for the state respondents, submits that he has been recently endorsed with a brief, and therefore he may be given 1 week, a week's time to prepare the matter. To stop the praise not objected to by the other side. Counsels for the opposite parties. In view of above, the matter stands adjourned for a week.
Obliged.
Obliged, Lordship.
19, 20, 21.
Yes.
May I please, your lordship? I beg to mention item number 18, hearing item number 18. Lordship, I'm appearing for the NIA lordship.
Mhm.
I pray that let the matter be fixed on 28th of August, lordship.
Why? Why not today?
Due to the road problem, the leading PP could not reach lordship.
Who is the leading people?
Mr. NN Mishra, lordship,
Mishra.
lordship.
You are there? Anyone appearing for the respondent?
I'm praying for respondent, my lord.
Any objection?
No, my lord.
You're on bail, isn't it? They want cancellation of bail.
Yes, my lord.
Lordship,
Okay, as paid for
28 August, lordship.
by the learned counsel for the appellant. This is the matter again on 28th of August, 2024.
Obliged, lordships.
May it please, my lord, chiefs. Lordship, I beg to mention item number 13. Fixed for hearing, Lordship, Senior Counsel Ken Chaudhary, he's unable to appear before this honorable court, so he has instructed to list the matter on 25th September.
Yes, other side,
No objection as far as the private respondents are concerned.
on a prayer made on behalf of Mr. Ken Chaudhary, learned senior counsel, appearing for the appellants and not objected to by the other side. List the matter again. On
25th September.
25th of September 2024 for hearing.
Obliged, Lordship. Lordship, I also beg to mention item number 10. This is to be listed before the single bench because by order dated 28/5/2024, this writ petition has been segregated from the contempt petition. Item number 10. So Lordship, be pleased to let this matter be listed before single bench.
Contempt petition is before division bench.
Yes, Lordship.
Apparently, Lordship, we don't know how this writ petition has been tagged along with the contempt, because the contempt pertains to implementation of the rules with regarding the retirement of judicial staff's, Lordship. Now, this writ petition pertains to seeking a direction for implementing the rules, Lordship. So that's how.
Not challenging the rules.
No, not challenging the rules, Lordship. So this should go before the single bench, Lordship.
Writ petition 21/2024.
Counsel,
Lordship, if my lordships peruse order dated 28/5/2024.
what does it say?
By this order, it has been segregated from the contempt petition. So this writ petition that has been segregated from the contempt ought to come before the single bench, to be listed before the single bench. (28/5/2024). This is in the contempt, Lordship.
Oh, in the-
In the contempt, that is,
All right, please write like this. Ms. Zimomi, learned counsel for the,
all my lordship can peruse this. I have just,
learned counsel for the petitioner submits that since the incident case has been segregated from contempt case C number 13 of 2021, the matter ought to have been listed before a single bench. To stop, the learned counsel submits that the matter pertains to prayer of the petitioner for implementation of the, what rules?
all Nagaland district employees service rule 2017.
All Nagaland district
District court employees
court employees rules. Which year?
2017.
2070. Stop. Next para. The said prayer is the said submission is agreed to by Mr. N. Mosui, learned counsel appearing for the
AG, Lordship, Accountant General.
Accountant
Respondent number
General.
4. 6.
And you also appearing?
For the state.
And Mr. V. Zimomi, learned state counsel, appearing for the state respondents. Stop. In view of above, list the matter registry to list the matter before a division bench, a single bench.
Lordship, the writ petition 21/2024.
Yes.
Obliged, Lordship.
Obliged, Lordship.
Please, Lordships. Item 17. Just this morning only I received the counter file by the state respondent. So this matter may be listed after 2 weeks, 17th. 16th and 17th is analogous.
They're clubbed together.
Yes, Lordship.
Mr. Lima,
Yes, Lordship. Lordship, I'm appealing for the appellant in item number 16. Lordship, these two are analogous.
they're analogous. So he is praying for 2 weeks. You affidavit filed by whom?
By the state respondents and
Okay.
even the private respondents filed yesterday.
Yes,
only.
Lordship.
You want to file a reply also?
I'll have to see, Lordship.
Okay. Mr. Kekring Uli, learned counsel for the petitioner in WPC number 296 of 2023 submits that he has just received a copy of the counter affidavit filed by the state respondents, and therefore he prays that he may be given 2 weeks' time to go through the same and to file a rejoinder affidavit if found necessary.
Yes.
Stop. The said prayer is not objected to by the learned counsels appearing for the other parties. In view of above, matter stands adjourned for 2 weeks. Petitioner may file rejoinder affidavit if so advised.
Lordship.
May I please, Your Lordship? Lordship, I beg to mention item number 4 on behalf of Sir Adil Ahmed. He has some personal difficulty today.
He is for which party?
I'm for respondent, for the sole respondent. I have taken the consent of the petitioner. Kindly list this matter on 23rd September, Your Lordship.
You're for the sole respondent?
Yes, Your Lordship.
Who's the counsel appearing?
I am not.
No.
Adil Ahmed, he's from principal bench.
Adil
A.
Ahmed.
Ahmed,
A. Ahmed, but his name is not shown.
yes, Your Lordship.
Mr. Yangawati,
My lord.
this is an appeal
My lord.
or a petition filed against the order of the CAT.
Okay, my lord.
What is the status?
As of now, the sole respondent has been reinstated.
Reinstated?
Yes,
When?
I have found my affidavit, lordship.
Has he been reinstated?
My lord,
Madam?
Lordship, I don't.
I have already filed my affidavit, lordship. Additional affidavit.
Just show us.
That was this annexure 11 in my additional affidavit. Order dated 28 June 2024 in my additional affidavit.
Additional affidavit.
Page 4, your lordship, additional affidavit.
No, this is your copy.
Yes.
Where's the court's copy? Yes, page?
Page 4, annexure 11. This is order dated 28 June 2024.
Yes, what is the instruction? Has he joined? He or she?
She.
Has she joined?
Lordship, I don't have any idea.
You should be more concerned. You have got an favorable order from the CAT. And respondents have filed appeal. There's no stay. They're asking you to join back into service. You should join. Anyway, when do you want it?
23rd September, Your Lordship.
Your good name?
Thea Kruller.
Ms. Thea Krule, learned counsel, submits that she's led by Mr. A. Ahmed, who is an outstation lawyer. Since she has some personal difficulties to appear before the court today, she prays that the matter will be listed again on 23rd of September.
Yes, Your Lordship.
Twenty-third is Monday. You should have it on 25th. Have it on 25th,
Monday.
since it's a DB matter.
Your Lordship, 25th.
25th of September 2024. Mr. Yangawati, learned counsel, learned CGC appearing for the petitioner, has no objection to the prayer. To stop, he further submits that the petitioner has issued a letter dated 28/6/2024 to the respondent, asking her to join back to join her duties immediately in view of the order passed by the CAT. Stop be that as it may, let the matter be listed again on 25th of September as paid for.
Yeah, please, Your Lordship. I beg to mention item number 15. I pray this matter may be adjourned for 2 weeks, as my senior is unable to attend the matter today.
Who's your senior?
Sir Siti Jamir.
Adjourned for 2
2
weeks.
weeks.
Yes.
Your Lordship, we have no objections.
Is there anything left?
Sorry, Your Lordship.
Is there any cause of action left?
I'm not certain, Your Lordship.
You're not certain. You're also not certain.
No, Your Lordship.
And we are supposed to be certain.
Apologize, Your Lordship.
Okay. Mention has been made on behalf of Mr. C.T. Jamir Lanet, Senior Counsel, appearing for the respondents, to the effect that as he has some personal difficulties to appear before the court today, matter may be adjourned for 2 weeks. To stop the said prayer is not objected to by the Lanet Counsel for the opposite party. In view of above, matter stands adjourned for 2 weeks.
Obliged, Your Lordship. Much obliged.
May I please, Your Lordship?
Yes.
I beg to mention item number 3 on behalf of my senior, Nityo Kaza, counsel for the petitioner. We have instructions to file the affidavit in reply. Please grant me 3 more weeks to file for the same.
Why 3 weeks?
May I please, Your Lordship? I'm appearing for respondent number 3.
Hmm.
The petitioners has been adjourning since 10th of April 2024, Lordship, without any genuine reason, Lordship. And so if the matter can be expedited, Lordship.
Last
it's a
chance,
2020
last
matter.
chance, last
Lordship,
chance.
Lordship, that can be recorded, Lordship.
Okay. As paid for, petitioner is granted 3 weeks' time to file rejoinder affidavit as a last chance. List again after 3 weeks.
Much
Obliged,
obliged.
Lordship.
All right.
For admission, item number 1.
Yes. You are Miss
Miss Lucino, my
Lucino,
Lord, my
yes.
senior is also appearing through VC today. Because of the bad road condition, he could not come to
correct.
court today, but he's appearing through VC. my Lord.
Mute.
You're on mute, I think.
It's muted.
Mr. Zimo.
Please, Your Lordships.
We can't hear you.
May it please, Your Lordships. Am I audible now?
Yes, now we can hear you.
Yes, my lords. So first point, my lord, the ROW issue which is pending in the Supreme Court,
Yes.
that is fixed on the 3rd of December. 3rd of December.
It is due to be listed on 3rd of December.
Yes, my lords.
So what does it have, what bearing does it have to this case?
This is, Your Lordships, the ROW issue, the right-of-way issue, which was not supposed to be an issue as far as the directions of the PIL is concerned. Because the direction was that the project should be executed on the existing road. However, the contractor has gone to the Supreme Court saying that unless the ROW is provided, he cannot execute the work according to specifications. So that is the issue which is now in the Supreme Court, Your Lordship.
I see. You are not available today because of the bad road condition.
Yes, my lords.
And even the VC condition also is bad.
It looks like that, my lord. It looks like that, my lord.
Now, what do we do? We wait?
Now,
December?
Yes.
on the last occasion, my lords, on the last occasion, there was an affidavit which was filed by the contractor, the respondent number 9.
Correct.
And he flagged certain issues with regard to the available right-of-way and safety concerns. And it appears from the affidavit file that the contractor has engaged a safety consultant. And Your Lordship will find that in the affidavit which was filed on the 13th of August. 13th of August.
Yes.
So there is a report of the safety consultant engaged by the contractor. Now,
Okay.
against this report, an affidavit has been filed by the respondents 1, 2, and 8 That is the Union of India and the NHIDCL, and they reject that report. They reject that report.
Okay.
So in the safety consultant's report filed by the contractor, the safety consultant says that there are certain accident risk areas, and in those areas, land should be acquired.
Mr. Zimomi, you are off and on. I can't hear you sometimes.
Yes, ma'am.
This is a problem.
Otherwise, better now, my
Anyway,
lord.
if we are to wait for that ROW thing pending
Yes, my
before
lord.
the Supreme Court, we might as well fix the matter on a date after that.
Yes, my lord.
Sir Joshua, what do you say?
Yes, your lordships. In fact, I wanted to show your lordships the issues raised before the Honorable Supreme Court. The entire issues which are in dispute here before this Honorable Court is already raised in the Honorable Supreme Court. And the matter is fixed, as my lord has rightly noted, it's fixed on 3rd of December,
Correct.
2024.
That's what Mr. Zimomi said, 3rd
Yes.
of December. So we have it after that.
But my lords, I want to have a
Now, in the
look at the
meantime,
issues raised before
meantime,
you.
what will happen?
Yes, my lords. So in the meantime,
Or the work is at standstill.
in the meantime, my lords, in the meantime, there has been a letter which was written to the contractor by the respondents 1, 2, and 8 with regard to the condition of the road because of the climatic conditions. So it seems there is extensive damage to the road, and the contractor has been asked to do the maintenance. So what does the contractor propose to do on that point, your lordship?
The contractor proposes to do what?
Your lordship, the contractor has been directed to undertake maintenance works on the existing road because of the climatic conditions, the incessant rain. There has been extensive
Okay.
damage to the road.
That direction has come from this court or from whom?
From the NHIDCL, from the respondents 1, 2, and 8. So that is an issue which needs to be addressed, my lords. And the other point, your lordship, I would be failing in my duty if I did not point it out. The time period for completion of the contract was extended to the 31st of May this year. We are past that date. So what do the respondents, what are they going to do about this? All the respondents, my lord, the official respondents as well as the contractors.
Yes, let
And
me.
according to the report, which was filed today by the respondents 1, 2, and 8, your lordships, the work completed is just 73%.
Can you all hear?
No, Lord.
Mr. Zimomi, we are having some difficulty.
Yes, my lord, the connection doesn't appear to be very good today.
The audio is off and on. I can't hear most of what you have submitted.
Can I try again, your lordships? Am I audible? Can I try again?
Yes, now you're audible, but then again,
Okay.
you go off again after some time.
Okay, my lords.
This is the
So, my
problem.
lords, the time period for completion of the project is 31st of May, 2024.
Yes.
In the affidavit which has been filed by the respondents 1, 2, and 8 today, the work completed is just 73%, 73 point something percent. There is an affidavit which has been filed today by the respondents 1, 2, and 8. So the work completed is 74.23%.
So let me ask the other side.
Yes, ma'am.
Mr. Joshua, what are you contemplating? The contract period extension period has lapsed on 31st of May. Now, what about the maintenance?
Your lordship, that the NHIDCL, since they have already written to us, they will be in a position to clarify before this.
Who is for the NHRDCL? Yes. What is happening?
Because of the matter is being pending before the Honorable Apex Court.
No,
Lordship.
that's one thing.
Lordship.
It's pending there. All
Yes,
the issues have been raised there and it's fixed on
Lordship, my
December.
concern is- yes,
That's one part. But what about the other part?
Lordship.
Now, the work, is it at standstill? Now, at this kind of monsoon period, there are, everywhere you're having this problem.
Yes, Lordship.
The maintenance problem, the maintenance issue, how are you addressing that?
Lordship, the contractor has filed an affidavit on the last occasion, Lordship, and we have filed a reply to that this morning, Lordship. Apart from that, Lordship, our concern is the inconvenience caused to the public, general public at large, Lordship. Now, my respectful submission before this Honorable Court is, Lordship, on several occasions, right from the date the instant BL was registered, Lordship, there are specific directions to the contractor to maintain and execute the road as per the available ROW, Lordship. Several occasions, Lordship. I have also filed an affidavit enclosing those orders, Lordship.
Now, our concern is that a direction should be issued to the contractor to execute on the available ROW till such matter is being disposed or decided by the owner of the Apex Court Lordship. The contractor has raised some technicalities, Lordship, and Lordship may also kindly appreciate that this concern project was de-scoped on the proposals submitted by the contractor, Lordship. Contractor has pointed out certain technicalities which was examined by the authority, Lordship, and it was approved on the proposal submitted by the contractor. He has foreseen about all this, the technicalities that he is facing right now, Lordship. Now, as per the affidavit filed by the contractor, the latest affidavit, it appears that they are taking a U-turn, Lordship. Therefore, Lordship, this is a public interest litigation. It is not an adversary litigation, Lordship. So if a direction may be issued to the contractor to execute, Lordship, and also, Lordship may also kindly appreciate the aspect that the Hornbill will be coming in the month of December, Lordship. And now, Lordship, it is all very important for the state of Nagaland.
Are you a party in the Supreme Court?
Yes, Lordship, we are party.
So what is your stand there?
Lordship, we are taking the similar stand, Lordship.
See, problem is that if the Apex Court is seized with the matter,
Yes, Lordship.
simultaneously, the High Court should not run a parallel proceeding and say that you do this and that, isn't it?
Lordship, as far as this,
What will be the submission before the Apex Court?
Lordship, the Supreme Court
Because,
has state only with regard to the termination notice, which we have issued to the contractor, Lordship. As on today, the Supreme Court has only stated the termination notice, which we have issued to the contractor, Lordship. Apart from that, no direction was issued, Lordship. And second aspect is, Lordship, with regard to right of way, Lordship. So long as the matter is pending before the Honorable Apex Court, Lordship, the contractor can also execute within the existing available ROW, Lordship.
The Lordships may also kindly appreciate this. Due to the problem which is lying in the existing road, not even the maintenance work, the execution of work also we cannot divide into two parts and conveniently execute the work. Secondly, Your Lordship, the maintenance work is becoming endless, and under the EPC mode of contract, my lords are aware that we're not getting paid for the excessive maintenance work that we have been doing, and then the contractor has been running into huge loss. So my lords, to have a better understanding, may I show the affidavits filed before the Honorable Supreme Court to Your Lordships? Because my lords, issues that my brother has raised now, and to the extent of the stay order granted by this Honorable Court, Your Lordship, that may be out of the context to be considered by this Honorable Court as of now, as my lord has rightly observed. It is pending, the same issue.
No, stay order, which stay order?
The earlier stay order issued regarding the termination of the contract work, as well as, what is the other issue? The ROW and the intention to terminate, Your Lordship.
They have issued a termination order.
No, the intention to terminate.
Intention to terminate.
Yes,
And that what has happened to that order? It has been stayed.
Yes,
Yes, Your
By-
Lordship.
by this
By
court?
the Honorable Supreme Court.
Okay.
And now, Your Lordships, may kindly go through this
So-
affidavit.
If your intention to termination is stayed by the Apex Court, then you are to proceed with whatever you have to do.
Exactly.
Isn't it?
Your Lordship,
You cannot say at the same time that I have a stay order, but I will not work because
no, it's not
ROW.
that we have not been working, Your Lordship. We have been. But as of now, Your Lordship, given the typical climatic condition as well as the
EPCD, just then it's order.
the land issue that we are facing right now, Your Lordship, because of the ROW issue and the width of the road, Your Lordship, the execution of the work has become extremely difficult for the contractor, and further execution of the work without any without any payment from the NHIDCL, Your Lordship, that problem it has become a severe problem for the contractor to execute the work further. So, Your Lordship, even in this affidavit that we have filed before the Honorable Supreme Court, we are asking us to be out of the contract agreement with the NHIDCL, Your Lordship.
Just then it's order. Division bench across EPCD.
My Lord, may I kindly come to paragraph 7 of the affidavit that I have just given to your lordships. May I read your lordships?
Yes.
That unfortunately, instead of curing the default as pointed out by the petitioner, the opposite parties via their letter dated 10/7/2024 refuted their defaults extra contractually and arbitrarily, which has compelled the petitioner not to continue with the project work, and to this effect, the petitioner is availing contractual remedies left to it as per the following reasons. It has become impossible to execute the work. One, the default of the respondent to provide required ROW with for construction of protection wall, shoulder, drain sections complying to the Hill Road Manual IRC 48, to the extent the work is not executed owing to the space constraints. Two, the threat of legal action against the petitioner, which would arise by way of regular casualties owing to rise of speed after laying of bituminous concrete. Three, huge non-payment of costs on account of required maintenance owing to inappropriate availability of ROW from the appointed date, that is dated 20/10/2020 and thereafter with effect from 31/5/2022. When the scope of the work has changed due to intentional default of the opposite parties, the petitioner was forced to incur a huge cost of account of maintenance work during construction period, particularly during monsoon period and post-monsoon as well. Most of our time has been consumed in doing maintenance work for which proper concentration cannot be made on original construction activities. The opposite parties, being a state entity, is not supposed to enrich itself at a cost of investment made by any individual. Your Lordship, further reading also, my Lord, which my learned brother for the NHIDCL has just pointed out. All these are issues that is now adjudicated by the Honorable Supreme Court. So whether, as my Lord has rightly pointed out, whether this Honorable Court, whether related to this particular issue can be taken up by this Honorable Court when the issue is pending before the Apex Court.
Basically, the case before the Apex Court is regarding ROW, isn't it?
And the execution, the difficulty of execution of the work, Your Lordship. And as far as my learned brother's submission is concerned, that since the work is going on, we should not, we have to continue doing all the maintenance work and all. And this same issue has also been raised before the Honorable Supreme Court. So,
but it's to be listed only in December. What happens before December?
Your Lordship,
we are only in August.
Let the NHIDCL also come with some instruction as to whether all this excessive maintenance work that we are doing within the limited width of the road, where we cannot do proper work and then most of our time is spent on maintenance work, whether there can be any modality that can be worked out to compensate the contractor, because under the EPC mode, my lords are fully aware that I'm not getting anything out of the maintenance works that my firm is continuously made to do, Your Lordships. And it has been going on even before the actual execution of the work. Due to good understanding between the contractor and the NHIDCL, the part between Kozama and Mao, there was a particular area where the mud sinking area, Your Lordship, the most severe area, even before the execution of the present contract work. For more than a year, the contractor was doing that work, and now that portion has become stable. After this, the present contractor came in the picture. But all this extra works that has been done by the contractor is not appreciated, and only the areas where the contractor has failed to execute. All those are the only issues raised before this Honorable Court. It's a thankless job, Your Lordships.
See, the maintenance part, is it not a part of the package otherwise?
No, Your Lordship.
Once you
that is why, Your Lordship.
No, once you construct the work, once you construct the road, you complete the road. For example, you complete constructing the road. So
yes,
there's some maintenance period, isn't it?
True, Your Lordship. As far as that is concerned, we're not disputing that. But now, due to the unforeseen possibilities of the problems that the contractor is facing right now, my Lord, it was not expected that this is the first time that the present contractor is also executing the work in this stretch of the road. The non-stability of the soil, the width of the road, the areas where some extra work is to be done also because of the non-availability of the width of road, and as far as some areas where even the village authorities can also cooperate with the contractors and then give some, at least 2-3 meters of the land to the contractor so that he can execute the work, but none of those help also came forward. And unfortunately, even the state respondents also under the district administration, because of the compensation issue, the Lordship, they have also not interfered in as much as the difficulties area where the contractor is facing problem in execution of the work.
Yes, Mr. Jamir.
So, my lord, before my brother speaks, if in fact it is the desire of the contractor that the NHIDCL may engage maintenance and repair contractor, your lordship, there is no problem with that. We have no issue with that.
Yes.
On that note, Lordship, there are provisions in the contract agreement, Lordship, specifically 10.4, 11.6, and 11.13, Lordship.
Regarding?
Engaged a different firm, Lordship, for maintenance and repair, Lordship, at the recent course of the contractor, Lordship. There are provisions.
Okay.
I've also stated.
Who will engage that? NHRDC will
Yes,
engage?
Lordship. Yes,
Okay.
Lordship.
So as of now, have you engaged or you have not
No,
engaged?
Lordship. But I've made a proposal, Lordship, that if this honorable court allows, Lordship, there is provision in the contract agreement, Lordship.
So where is that proposal for engagement?
Lordship, I have stated in my affidavit, Lordship, which I
Let us-
filed this morning, Lordship.
This morning?
Yes, Lordship, this morning.
What does it say? Tell us.
To engage, Lordship, seeking a permission before this honorable court to engage a different firm or contractor, Lordship, at the recent course of the contractor, Lordship. There is provision, Lordship. And which was also invoked in other projects, Lordship.
Otherwise, so far, who has been doing the maintenance?
Lordship, it's the contractor, Lordship. It is part of the contract.
Respondent number 9.
Yes, Lordship.
So apart from what he has been doing, maintenance,
Lordship,
since the contractor says that he has been doing that out of his own pocket without any chances of getting it reimbursed, you say that there's a provision under the contract agreement that you can make alternative arrangement for maintenance.
Lordship.
Have you quoted in your affidavit 10.4? Have you quoted?
Affidavit is not on record. Let it be on record. We'll take it up again.
Lordship.
Lordship.
Next Wednesday, we'll take it up again.
My lord.
Let the affidavit be brought on record.
Your lordship.
See, you may have approached the higher forum for your interest. But then again, we are also concerned with the interest of the public here in the state. How things are to be, like how things will go on now.
Lordship.
Season is here now, rainy season is there, no doubt.
Lordship.
But then the maintenance will have to go on,
Yes, Lordship.
isn't it?
Yes, Lordship.
And it's not that the matter is fixed next month, it's in the December.
Yes, Lordship.
So how long can we wait for that?
Yes, and that is also our concern, Lordship.
Mr. Zimomi, we'll have it next week, Wednesday, again.
That's all. That's all. right.
The NHRDCL respondent numbers 1, 2, and 8, right?
1, 2, and 8, Lordship.
You have filed an affidavit.
Yes, Lordship.
We'll have it again on Wednesday. Is it a working day? Please write down, parties are represented by the respective councils. At the outset, Mr. Jamir, learned counsel for respondent numbers 1, 2, and 8, submits that the NHRDCL has filed an additional affidavit this morning, wherein it is stated amongst others that there are certain provisions for engaging
Contractor for maintenance and
a contractor for maintenance
And repair.
repair.
and
Lordship.
repair
Yes, Lordship. At the recent course of the contractor, Lordship.
at the risk and cost of the appointed contractor.
Yes,
That is their submission, your lordship.
It's okay, that's. Stop. Since the said affidavit is not on record, let the matter be listed again on 28th August. Office to verify and connect the affidavit, additional affidavit so filed by the respondent numbers 1, 2, and 8 to the record.
My lords, my presence may also be reflected
Yes.
Yes, in the beginning, I had covered everybody. You want me to mention?
Okay, that's fine then, my lords. That's fine.
I said parties are represented by the respective councils. So it covers everybody.
Lordship, if the action may be issued to the authority engineer to file the progress report, Lordship, as on the latest report, Lordship.
Authority engineers,
Yes,
respondent number,
10, Lordship.
who's appearing? Can you file by next week?
Yes, my lord.
Okay, the respondent number 10, authority engineer shall submit an additional affidavit indicating the latest progress report.
Your Lordship, if necessary, I may also be allowed to file an addition, an affidavit because of the contentious issues raised by the respondent NHIDCL.
We'll see, we'll see. At the
Otherwise, there's
moment,
nothing adverse against them, Lordship.
correct. By the next date, okay? Now, see, what was the progress on the last occasion?
74, Lordship.
Yes,
74.
yeah, a little more than 74%, Your Lordship.
Hopefully this time it should be more than that. It was 73.55. Correct?
Your Lordship, perhaps is the,
That was when we
Yes.
had taken
my
into
lord,
account the affidavit filed sometime in June. It was 73.55.
Yes, of yesterday, lordship, it is 74.23. The physical
Okay,
progress.
okay. You file it, we'll see.
My lord.
oblige Your Lordships.
Much obliged, my lords.
For admission, item number 2.
May I please, Your Lordship?
Yes,
Lordship, I'm bringing for disposal of the case today, if it is convenient to Your Lordship.
disposal or dismissal?
My lord, that is up to the court. It may be this, it could be at my risk.
What is this, a writ appeal?
It is a writ appeal, Lordship. My lord, I am aggrieved by the imbue order, judgment in order dated 1/3/2024 passed in WPC 126 of 2023.
How many petitioners were there?
Well, sole petitioner,
Sole petitioner,
sole petitioner, my lord, no private respondents,
no private
no private
respondents.
respondents.
Your writ petition was dismissed.
My writ petition was dismissed.
What was your prayer?
My lord, yes. My lord, can you allow me 5 minutes to give a briefing of the case? So before I go to the facts. Lordship, the petitioner is a graduate teacher. He was appointed on contract in the year 1993. After he was appointed, he was given 2 advance increment for having PhD degree.
Graduate teacher,
Yes, graduate teacher.
teaching in what?
Government high school.
High school.
Government high school, under the Department of School Education in the government primary middle school, he was appointed. My lord, later on, I need to go through the facts. Documents, which, if you can, Lordship, may kindly listen for 5 minutes, then I'll go through the facts so that you get a gist of the issue.
Graduate teacher, teaching in high school.
Teaching in high school,
He's got B.Ed degree also.
he has got B.Ed degree, he was given 2 advance agreement. Thereafter, my lord, on completion of 10 years of continuous service, counting from the date of his initial appointment, he was given senior scale of pay. As a senior graduate teacher, he was promoted, given scale as a senior graduate teacher, counting from the date of appointment in the year 1993 as on contract. Thereafter, my lord, he was given MSCP with effect from 16/1/2004 on in the year 2014. MSCP.
Why is it required, MSCP?
My lord, since career progression, he could not be promoted. There's a
But you said you got senior grade.
senior, he was given senior graduate teacher after completion of 10 years.
Graduate teacher,
Senior
senior grade,
graduate teacher.
selection grade. So where's the question of
My lord,
MSCP?
my lord, the graduate teacher is only a designation given as advanced increment. But then MSCP, since he could not be promoted to assistant headmaster.
Oh, headmaster.
Yes, or headmaster onward, there was a career in stagnation, so he was given MSCP with effect from 16/1/2004. Now, Lordship, the government came on with a policy through an office memorandum on 18/2/2004 for a regularization scheme was framed. Lord, that is prior to OMRDB. Now, my lord, here, two categories, I'm confining to two categories. One, persons who was appointed holding a substantive post, appointed on contract in ad hoc, and were in continuous service, and who had completed 10 years of service as on 16/1/2004. My lord, 16/1/2004 is the date of cabinet decision. So, my lord, counting the date of cabinet decision as 16/1/2004, when the policy was framed, Lordship, people who had completed 10 years on ad hoc or contract on continuous service, completed on 16/1/2004, without any screening test, they were regularized with effect from 16/1/2004. That is the date of decision by the cabinet.
That's the first category.
That is the first category. Lordship, I'll show the order so that I'll show the document so that I was also eligible since I was appointed in the year 1993. So the controlling officer, the TIS of MON, forwarded my name along with similarly situated persons. Then the second category of persons, people who had completed 5 years of service as on 16/1/2004. My lord, you need to be, the condition is you should face a screening test, and on being qualified in the screening test, they are also to be regularized with effect from 16/1/2004.
Difference is screening test.
Difference is screening test, availability of a substantive vacancy with requisite qualifications. Now, my lord, in the year 2006, department decided to implement the policy of the government. Now, in 13/1/2006, a decision was taken by the department that people who had completed 10 years as on 16/1/2004 should be regularized from the date of their initial appointments. Thereafter, my lord, it was changed, and finally, my lord, on 16/1/2004, my lord, sorry, on 12/3/2009, government came to a final decision that from the date of cabinet decision, that is 16/1/2004, accordingly, the regularization order was for 183 teachers. They were issued on 12/3/2009. Unfortunately, I was left out. I missed the past tense, though I was recommended. I submitted representations then. Thereafter, my lord, by the immune order dated 5/10/2010, I was, along with some other persons, I was regularized only with effect from 18/5/2010. That is the date on which the second cabinet took that is the date of the second cabinet meeting when the scheme, the regularization was approved. So, my lord, I was left out. Now, thereafter, my lord, I submitted a representation on 15/9/2010. Then my service was confirmed. Thereafter, my lord, in the year 2012, those who had completed 5 years of service as on 16/1/2004, my lord, 39 of them were regularized with effect from 16/1/2004 under the second category. So, my lord, my juniors, my lord, I took a ground that even presuming and not admitting the fact that due to various reasons, I was not qualified, even presuming. In the first category, I have a superior claim over those 5 years, my juniors. That aspect, my claim of my superior claim over 5 years of service, my juniors was not taken into consideration by the learner single bench when the judgment was delivered. I'll come to that. But I'm reiterating that I'm qualified under category 1. Now, my lord, thereafter, my lord, I had submitted representations to the government. I have been submitting representations. Then finally, on 2023, the principal director of the department forwarded my case to the department, that my case to be examined and considered. Since unfortunately the department was sitting over the file for a very long time, and my lord, accordingly, my lord, I came before this honorable court and I filed a writ petition on 17/7/2023. Notice was issued on 27/2023. And during the pendency of the writ petition, my representations which were submitted and forwarded by the principal director was rejected by the government only on 6/10/2023 during the pendency of the writ petition. My lord, in the affidavit in opposition filed by respondents, the rejection of my representation letter was enclosed. My lord, that is the gist of the issue. Now, lordship is well aware that when a rule is challenged, it is only the necessary party to be implemented. It is not necessary that the petitioner is not bound to implement the proper parties. People without whom, respondents without whom the judgment decision cannot be taken should be implemented, and persons at large who will be affected by the rules need not be affected. They are at the most proper party. Now, my lord, relying on two judgments of the Honorable Supreme Court, I challenge only the use of a different yardstick, arbitrary and action of the respondent while applying the policy. A different yardstick, which is violative of 14 and 16, was used against me when I was regularized with an effective date. So, my lord, the Honorable Supreme Court says that when the general administrative action with regard to absorption or fixation of seniority being violative of 14 and 16 is challenged, the proceedings are analogous to those in which constitutionality of a statutory rule regulating seniority of a government is assailed. In such proceeding, necessary parties to be implemented are those against whom, my lord, relief is sought and in whose absence effective decision cannot be rendered by the court. So, relying on these two judgments of the Supreme Court, well, I'll substantiate subsequently with the judgments. I did not challenge any seniority list, nor I had challenged any officiating promotions of my juniors. I came before this honorable court only challenging the wrong application of a different yardstick, arbitrary action of the respondent while interpreting the policy office memorandum of 2004 for regularization of the petitioner. Accordingly, my lord, I have met only the necessary parties, the government as respondents. I did not implement any private respondents, nor I am challenging any seniority list promotion before the honorable court. Unfortunately, that aspect of the issue, my lord, the learned single judge has only brushed it aside, saying that it is an intelligently drafted writ petition, but then third party interest involved. Now, my lord, the learned single judge it is a CAV. The learned single judge had decided the case on three issues. The first issue was learned single judge, my lord, examined. First issue is whether I was holding any substantive post at the time of my initial appointment. That was the first consideration. My lord, the respondent's contention before the single bench was that I was appointed against a transfer vacancy and there was no substantive vacancy. When you managed to locate a substantive vacancy in the year 2010, I was regularized there. That is the contention of the government's affidavit. So accordingly, my lord, the learned single judge had held that I was not holding any substantive post at the time of my initial appointment. As such, I'm not entitled for regularization under the first category with effect from 16/1/2004. The learned single judge has also failed to take into consideration my superior claim over those who have completed 5 years of service. continuous service as on 16/1/2004 because, my lord, they were subsequently regularized. So the vacancies, substantive vacancies were there. Secondly, lordship, the learned single judge, second issue was, learned single judge, second issue is whether the petitioner is entitled for regularization with effect from 1993 or from 2010. Now, my lord, the issue before the learned single judge was that whether I'm entitled,
Just a minute.
lordship,
Why do you say 1993?
my initial appointment.
No, you were saying that cabinet decision was
Yes,
16/1/2004.
that is why, my lord.
So all of your counterparts have been regularized from this date,
My lord,
not from 93?
I'm only my lord, I'm only submitting the issues framed by the learned single judge.
Okay.
That's how I'm finding fault. The learned single judge, instead of, my lord, deciding whether I'm entitled for regularization with effect from 16/1/2004 in terms of the office memorandum of 2004, the second issue framed the learned single judge was that whether I'm entitled for regularization with effect from 1993 or 2010, that is the impugned order. So, my lord, the second issue framed by the learned single judge is contrary to the subject matter of the case. My lord, if necessary, my lord, I will show you the page 53.
You have been regularized from which date?
My lord, I have been regularized with effect by an order dated 5/10/2010, with effect from 18/5/2000, with effect from 18/5/2010.
18/5/2010.
Yes, lordship may kindly see the issue frame at page 53, paragraph 19. May I read, my lord?
Yes.
On the basis of the pleadings noted above and the submissions made by learned counsel for the parties, the 3 points for determination arises for consideration whether the petitioner was entitled to be considered for regularization in category 1 of the office memorandum dated 18/2/2004. 2, whether in terms with the order of regularization dated 5/7/2010, the interest seniority of the petitioner are required to be fixed as on 16/12/3/1993, that is the date when the petitioner was appointed on an ad hoc basis. 3, whether the instant writ petition suffers from any delay or laches. These are the 3 grounds framed. So I'm only relating, my lord. So, my lord, the subject matter was whether in terms of the office memorandum, I am also entitled to be considered for regularization with effect from 16/1/2004 or not, like the others who have been like the others 10 years of service, and my juniors 5 years of service. That was the subject matter, but the learned single judge, my lord, this is one of the reasons. Thirdly, lordship, the learned single judge, my lord, my respectful submission is that after my submission of my representations, yes, I think that I have been approaching the authorities by submitting representations. And lordship, finally, my case was recommended for consideration by the principal director, my lord, at page 145. May I read, lordship?
Yes.
On the subject cited above, I am the forward herewith an application received from Rakesh Ranjan, graduate teacher in Government High School, Pomjing Mon. It is to be noted that Rakesh was appointed as a graduate teacher science on ad hoc basis on 12 March 1993. Later, he was regularized on 5 July 2010 with the condition that the effective date for regularization will be with effect from the date of cabinet approval, that is 18/5/2010. The teacher has stated that he has submitted all required documents to the department as per government approval dated such and such for regularization. However, his regularization was delayed. Delayed May 2010 instead of 24 October 2006, when he had already completed 10 years of service as on 16 January 2004. The matter is therefore forwarded to the government for kind information and necessary action. Thereafter, my lord, Lordship, my lord, it was, my lord, kindly allow me to show the rejection order. My lord, 278. During the pendency of the writ petition, my representation was finally rejected. My lord, 277, this is a government affidavit. My lord, 277 is the one which I have just read. The next repeat to the government's affidavit. And 278, may I read, my lord?
Yes.
I am directed to refer to your letter dated 24/2023, my lord, that is 277, which we have just read.
Yes.
And the representation submitted by Mr. Sri Melissa AHM and five others recently promoted. Under subject cited above, and to state that the government's stunting rules are followed in the regularization and preparation of seniority list, which is applicable to all employees under Directorate of School Education. The same may be communicated to the applicants. My lord, this is the second paragraph is important. Further, you are requested to furnish detail as to why the representation copy enclosed were left out in the proposal while considering for promotion in the first place. So, my lord, my representation was finally rejected on 16 October 2010. My lord, kindly allow me to read paragraph 6 at page 270.
No, before that, this page 278, which you just read.
Yes.
Is it a rejection order?
My lord, the first paragraph.
And to state that government standing rules are followed in the regularization and preparation of seniority list, which is applicable to all employees under the so-and-so.
Then, my lord, the second part, government give a direction to the department to details as to why I was left out in the first list.
Correct, but it doesn't say reject.
My lord,
It says that
Lordship,
they have followed the government rules and regulations.
my lordship, may kindly allow me to read paragraph, page 270.
270. Statement.
Yes. My lord, the last 10, 15 lines I'm writing. In this regard, the directorate by letter dated 24/2023 forwarded his case to the government, and government by the letter dated 6/10/2023 has conveyed that the government's stunting rules were followed in the regularization and preparation of the seniority list, which is applicable to the petitioner and all employees under the department, as explained in the foregoing paras. In the instant case, the petitioners were appointed without a sanctioned post due to shortage of teachers in the government middle school. At that point of time, I'm acquiring professional qualification. He was given pecuniary benefits inadvertently, although he was still not regularized.
Pecuniary benefits.
Pecuniary benefits, my lord, MSCP. My lord, that is an issue I'm coming.
That is to be given only to regular employees.
That is to give it. That is to be given to only regulars. What has happened, my lord? Completion of 10 years of, my lord, my promotion as a senior teacher on completion of 10 years of regular service, counting from 1993. My lord, and the fact that I was given MSCP with effect from 16/1/2004, like the others who were like the other similarly situated person who were regularized with effect from 16/1/2004, my lord, I took two grounds as a plea to prove my substantive appointment. Now, my lord, in the affidavit in opposition of the government, my lord, he took a stand that I was given MSCP inadvertently, and my lord, I was issued a letter. My lord, lordship, you kindly see page 282. May I read, my lord?
Yes.
My lord, lordship may kindly see the subject matter, the PC 126. With reference to the subject cited above, it is to bring to your notice that department on perusal of the above-mentioned writ petition has detected that due oversight, first leave of financial upgradation under MSCP was erroneously granted to you with effect from 16/1/2004, whereas you are eligible to grant first leave of financial upgradation under MSCP scheme with effect from 18/5/2020, in line with your effective date of state service regularization, meaning mention will be made herein that the length of service required for first lift under MSCP scheme is 10 years with effect from date of regularization. You are therefore requested to submit your service speak to the department for cancellation of the wrong grant of MSCP to you. Now, my lord, since this issue has been raised, kindly allow me to address this issue before I go. My lord, page 272.
Yes.
My lord, page 272, paragraph 9. The same which I have read is raised for the first time in the affidavit in opposition by the government. So, my lord, lordship, thereafter, lordship may kindly come to page 256. My affidavit in reply, lordship. The second paragraph, page 256. The deponent respectfully says that all the other similarly situated persons, including his juniors, were regularized with effect from 16/1/2004, except the deponent. As such, the principle of justice in fair play demands that he should be regularized with effect from 16/1/2004, and MSCP granted to him with effect from 16/1/2004 should be protected for the ends of justice. Now, my lord, I have made a submission, my lord. Thereafter, my lord, lordship may kindly see at paragraph 10 of the judgment, page 45. Quick glance only, my lord. The learned single judge has reached the issue of granting MSCP to me at paragraph 10. Then lordship may kindly come to page 48, last line of page 40 is paragraph 13, lordship. Page 48, my lord, from the last three lines from the bottom, page 48.
Yes.
It is further mentioned that on account of oversight, first lift was erroneously granted with effect from such and such. The petitioner was actually eligible with effect from 18/5/2005. 10. By the order dated. So this also was, in this regard, for rectification, department had intimated the petitioner to submit his service book. Further, that preliminary objection was taken on the ground of such and such. Now, my lord, the Honorable Supreme Court judgment of 1965, I'll raise this issue. I'll submit the judgment in due course. It says, my lord, that any issue raised in the affidavit in reply can be a basis to decide the case. My lord. So I'll submit the judgment. So, my lord, before the learned single judge, my lord, my submission on MSCP was that if I'm regularized from 16/1/2004, then it will be automatically regularized. It will be because 10 years will be perfect. But in the event the petition was rejected also, my lord, in view of the judgment, there was no fraud involved on the part of the petitioner for obtaining it. It is clear case of respondent that it was given to me by mistake. And also, my lord, the Honorable Supreme Court judgment on the guideline, the principle laid on for recovery, grade 3 and grade 4 not to be recovered at any cost. I'll come with the judgment. So, my lord, on the issue of MSCP, my lord, I raised this issue that in any case, whether the writ petition succeed or not, there should be no recovery. But this aspect of the matter also was not considered by the learned single judge. Though he had discussed the matter, he did not give any finding as to whether, my lord, on this issue. So, my lord, in the writ appeal, my lord, I have taken that ground also to set aside the letter which we have just read, and then IA also was filed, not for recovery till the disposal of the case, but last week in the matter was listed. The division bench, later division bench was the view that both the writ petition and the IA to be heard together. Last witness, that's how it is attacked along.
Okay, tell me one thing.
Lordship.
What was the intention when they gave you that notice for you to submit your service books?
So that, my lord, the last lines.
They wanted to recover?
Yes.
Where's that page? You have shown us 282, is it?
My lord, the last line, 282.
282.
Yes, last line. Therefore, you are directed to submit your service book to the department for cancellation of wrong grant of MSCP to you. Cancellation means recovery, lordship.
So it went to that extent only, isn't it?
Lordship.
There's no such other notice to recover.
No, lordship. I have made a categorical statement in my writ appeal that I had not, till date, I did not submit my service book, and the recovery is yet to be done.
This was not your submission in the, this is not the document which you submitted in the writ petition, isn't it?
It is your document.
It is
during the pendency, lordship.
In the counter affidavit, they enclose
in the
this.
counter affidavit, they enclose in your affidavit in the opposition. So in my affidavit in reply, I raised this issue that it should be protected. Now, that is why, my lord, I'm making a submission. My lord, kindly allow me to submit a judgment on this before we go. My lord, AIR 1965, SCC 1578, paragraph 17.
AIR or SCC?
AIR 1965, SC 1578.
This is on?
On the filing of issue to be taken up on the reply affidavit. Because, my lord, since it came in the form of counter affidavit, in my reply, I have shown you, your lordship, that I make a to a ground that it should be protected. My lord, 1588, paragraph 17.
One 1588 or 78?
Paragraph 17, 17, lordship. Paragraph 17.
The page number is 1588.
1588, lordship.
Okay.
1582, I'm sorry. 1582, I'm sorry.
1582.
Paragraph 17, 17.
Yes.
Married, my lord.
Yes.
That takes us to the consideration of the question as to whether the two reasons given by the High Court in support of this decision are valid. The first reason, as we have already indicated, is that the High Court, though that the plea in question has not been raised by the appellant in the in his writ petition. This reason is no doubt technically right in the sense that this plea was not mentioned in the first affidavit filed by the appellant in support of his petition, but in the affidavit in rejoinder filed by the appellant, this plea has been expressly taken. This is not disputed by Mr. GT, and so when the matter was argued before the High Court, the respondents had full notice of the fact that one of the grounds on which the appellant challenged the validity of the impugned order was that he had not been given a chance to show cause why the said notification should not be issued. We are therefore satisfied that the High Court was in error in assuming that the ground in question that has not been taken at any stage by the appellant before a matter was argued before the High Court. So, my lord, my respectful submission is that since the matter was raised for the first time in the affidavit in opposition, in my affidavit in reply, I took up the issue and it was argued. But the learned single judge did not give any finding. It was discussed, but he did not give any finding because, my lord, in the writ petition, that was not there. It is subsequent development after the filing of the writ petition. Now, my lord, giving the brief, broad outline, and lordship may kindly allow me to read paragraph 13 of my read appeal and paragraph 10. Page 10. Page 10, paragraph 13. May I read, my lord? That the petitioner appellant has stated that the subject matter of the WC 126 of 23 was a challenge to the arbitrary, illegal, and discriminatory action and wrong application, general administrative action application of a regularization scheme formulated through a policy of the state cabinet with regard to observation and fixation of seniority, the action of the respondent authorities being violated of Article 14 and 16 of the Constitution of India. The proceedings are analogous to those in which the constitutionality of a statutory rule regulating seniority of government servants are assailed. In such proceedings, the necessary party to be implicated are those against whom the relief is sought, and in whose absence no effective decision can be rendered. In the present case, the relief is claimed only against the government of Nagaland, the Department of School Education, which has been implemented through its representative. No list or order fixing seniority of the appellants vis-a-vis particular individuals, their official promotion pursuant to the impugned decision of the respondent authorities are being challenged. The employees who are likely to be affected as a result of the readjustment of the appellant state of regularization as seniority strictly in accordance with categories such and such, with all consequential benefits were at the most proper parties and not necessary parties, and their non-joinder would not be fatal to the writ petition. My lord, this is a ground which I have taken. Now, my lord, lordship may kindly come to page 63 of the judgment, paragraph 31.
Yes.
The last 5 lines. In the present, my lord, in the present cleverly drafted petition, though no relief has been sought challenging the various promotional orders made to those persons who are senior in the seniority list, but any writ issued granting the relief herein would definitely affect those persons who are above in the seniority list. That is the finding of the single judge, but the judgment which I have relied upon, my lord, at paragraph 17, page 51.
Yes.
Further to that, the learned single senior counsel submitted that there is no necessity of implementing other person in as much as the reliefs which have been sought for by the petitioners are only to grant the benefit to the petitioner by making certain changes to the industry seniority list and consequential benefit to which the petitioner thereupon would be entitled to. He therefore submitted that as no rights to the third parties would be affected by the reliefs if granted by this court, the question of delay in laches or for that matter non-implementation of the other person would affect the maintainability or the interminability of the instant writ petition in this regard. And my lord, my judgments which I had relied upon. Now, my lord, can you allow me to, having a gist of the issue, can you allow me to quickly go through the documents?
Sure.
My lord, my initial appointment is at page 65. My lord, the type copy 66. Married, my lord.
Yes.
Mrs. Rakesh Ranjan is hereby appointed on ad hoc basis as graduate teacher at government such and such under TPI's such and such with all other allowances at the rate in the scale of pay of rupees 775 such and just as and interline compensatory allowances, basic P with all other allowances at the rate prescribed by the government of Nagaland from the time to time with effect from the date of joining up to 34/1993 against Vice 3 ND Shitri Assistant Teacher transferred to Government High School Chunlika. The appointment is purely an ad hoc basis interminable without any period notice. No detection towards GBF or group insurance scheme will be made. The service will be terminated after incumbent remain absent from duties for more than 1 month without proper leave. The incumbent is informed to join his duty within 1 month from the date of issue of this order, filling which this offer of appointment shall be treated as none accepted and cancelled. So, my lord, I was appointed upon the transfer of one NT Shetty. My lord, I have made a categorical statement in my writ petition that Mr. Indi Shetty it is a normal transfer. It was not a transfer with post. So the vacancy was there. My lord, the order also says against the transfer. It does not say anything that it does not say transfer with post. My lord, normal circumstances, somebody was transferred out without a reliever. It's a science post, science teacher post in 1993. So there was shortage. So once this gentleman was transferred, against that vacancy, I was appointed.
What is this A teacher?
Assistant teacher.
Okay, assistant teacher.
And my lord, my appointment is not fixed. It is in a regular scale of pay with all other allowances. Then, my lord, lordship may kindly allow me to that at page 73, I was given 18 June 1993, I was given 2 advance increment for having PET. Type copy 74, lordship. My lord, unless somebody is regularly appointed against a vacancy, such advance increment is not given for, my lord, somebody who is appointed on contingency, my lord. Contingency appointees are not entitled for advance increments. Only regularly appointed are entitled. That lordship may kindly take note of that. Then, my lord, page 75. My lord, merit. The type copy is 76, lordship. It will be more legible. Having completed 10 years of continuous service, the following teachers under the establishment of Deputy Inspector of Schools are hereby granted senior skill of pay as mentioned against each. My lord, my name is serial number 5, Rakesh Ranjan. My lord, scale of pay is mentioned. My lord, the effect date is 18/12/8/2003. So, my lord, 10 years of continuous service was counted from my initial appointment. Yes. Well, my lord, my initial appointment was 12 March 1993. And my lord, lordship may kindly note that this order has not been superseded or revoked till date. Granting of senior scale of pay, counting with effect from 12/8/1993 and completing 10 years as on 12/8/2003, my lord, this has not been revoked. It still stands today. My lord, my MSP was withdrawn. This order has not been revoked. Then, my lord, the next page is the MSCP. My lord, lordship type copy is 79. My lord, having completed 10 years, my lord, 16 March, my lord, lordship may kindly come to page 80. It's serial number 96.
Yes.
Rakesh Ranjan, my lord. My lord, initial appointment 12/3/1993 at column number 4, and then effect date of promotion 16/1/2004. My lord, 16/1/2004 is the date of regularization of other similarly situated person in my juniors.
This is the first MSCP.
Yes, which is now withdrawn. But Lordship may kindly see the effective date, 16/1/2004. That is the date of regularization of the other similarly situated persons. People who had completed 5 years and 10 years were regularized with effect from 16/1/2004. So that same basis was taken for me when MSCP was granted to me.
16/1/2004.
my lord. Lord, date of promotion to the present post, my lord, 1, 2, 3, 4, fifth column.
Date of promotion to the present post,
That is MSCP, yes.
2004.
Yes, 16/1/2004.
Counting from?
My lord, counting, that means counting from 16/1, my lord, count, my lord, 16/1/2014, I'm sorry, 16/1/2014, counting from 16/1/2004.
10 years.
Yes, my lords, 16/1/2004 was the date given to all my similarly situated persons and my juniors. They were regularized. People who had completed 10 years and 5 years were regularized with effect from 16/1/2004. I'm coming to that. So, my lord, taking that same criteria, I was also given reckoning with effect from 16/1/2004. So, my lord, qualifying is 16/1/2014.
See, your appointment was 93.
93.
Then your increment given to you is in 2008.
Yes.
After completing 10 years.
Yes. So that is a different aspect.
Then the MSCP comes in
Yes.
2014.
Yes. Counting with effect from 16/1/2004. 10 years.
Why this date, 16?
My lord, 16/1, because lordship may kindly see at page 79, that is on completion of 10 years of regular service.
Counting from which date?
16/1/2004. My lord, that is what I'm submitting.
No, 16/1/2004.
My lord, my regularization is 2010. My regularization is 2010. However, my lord, when the MSCP was granted, the department thought it fit that I also, my MSCP should be given from 16/1/2004, the date on which the similarly situated persons who had completed 5 years and 10 years of regular service were regularized with effect from 16/1/2004. That same yardstick was applied to me and I was given MSCP accordingly.
No, apart from that date being common to other similarly situated persons.
Yes.
Is there any other reason why that 2004 date has been taken?
My lord, that is the date of cabinet decision.
Cabinet decision, that's why.
16/1/2004 is the date of cabinet decision.
Oh,
I'm
that's
coming to the
right.
document, to the office memorandum when that will be clarified, lordship.
Okay, Mr. Takamasa, we'll just take 5 minutes
Please,
break.
please.
Come back.
Lordship. If he asks, then yes. Lordship, may kindly turn to page 81, the regularization scheme. I'll quickly show the condition.
Yes, yes. This is the basis of your claim.
Yes, this is the basis of my claim. And my contention is that a different yardstick other than what is provided here is applied to me. So I'm only challenging the wrong application of the principal, Lordship, not seniority promotion. Married, Lordship. Regulation of contract and ad hoc appointments. This is 18th February 2004. The governor of Nagaland constituted a committee by notification dated 4/2/2003 to examine the issues relating to a large number of ad hoc contract employee appointed in the past in various state government offices and recommended a workable solution on this record. On the basis of recommendation of this committee, a set of measures to be taken to deal with the existing situation and to prevent a recurrence of such appointments in future was placed before the cabinet, which was considered and approved by the cabinet on 16/1/2004. That is how, my lord, 16/1/2004 become the basis, the approval by the cabinet.
Yes.
In pursuance of this decision, the government of Nagaland is pleased to order as follows. My lord, can you allow me to skip this? I'm only reading the category. Merit.
Yes.
Category 1, ad hoc contract appointments made against sanctioned post. A, employees having more than 10 years of service, an employee in this category may be considered for regularization provided there is a sanctioned post. The employee fulfills all the eligibility criteria to the post, including the requisite educational qualification. The performance of the employees has been satisfactory in the service. My lordship, may kindly see A, there is a sanctioned post. It does not say that the petitioner person incumbent should be holding a sanctioned post. It only says availability of a sanctioned post. My lordship, may kindly see there is one, there is a sanctioned post. So on that day, whether a sanctioned posts were available to accommodate them, that is the issue. However, my lord, the government affidavit, the stand of the government and the learned single judge is that I should have been holding a sanctioned post personally. But all along my contention is only whether there is a sanctioned post available to consider my case on the basis of seniority. on the basis of the criteria. The concerned department will submit specific cases to the government for approval after obtaining the recommendation of the screening committee with the following compositions. Then my lordship may kindly come to the next one, B, the employees 5 years and 10 years, next page. And employees having 5 to 10 years of service, an employee in this category may be considered for regularization, provided that in addition to the above mentioned 3 criteria, namely, there is a sanctioned post, the employees fulfills all the eligibility criteria for the post, including the requisite educational qualification, the performance of the employee has been satisfactory in the service, and examination written in or viva voice to test their suitability should be organized by the concerned department under the supervision of Administrative Training Institute. Qualifying marks should be laid down in advance, and only those who qualify such screening tests should be considered for regularization by following the procedure as mentioned in 3A. 3A is about the 10 years. So screening test. Besides the 3 conditions, they need to face a screening test. And after being qualified by the screening test, it will be forwarded and to be approved by the cabinet. Now, my lord, since I was appointed in the year 1993, my lord, I had 10 years of service. Lordship also may kindly appreciate this fact that this policy is prior to Omadivi. Then, my lord, at 84, page 84, lordship, 18 June 2004.
See, you say that you're covered by this first category.
Yes.
What do the respondents say?
My lord, the respondent says, the affidavit of the respondent says, I was not appointed against a sanctioned post. So when in 2000, only when in the year 2010, when you were able to adjust a substantive vacancy, I was regularized there.
How were you adjusted? Any document? 2010?
My lord, that is the affidavit. I'm showing the affidavit. My lord, if your lordship may kindly allow me to read the affidavit of the respondents.
So after being adjusted to a regular sanction post, you fall under which category? 1 or 2?
My lord, I does not fall into any of the categories.
But you have been regularized.
I have been regularized.
How?
My lord, through cabinet. I'll show my regularization orders subsequent to this.
Cabinet was 16 of January 2004.
Yes.
Then the second cabinet was later on again in 2010.
Yes. My lord, so my regularization order, page 94.
A separate memorandum has been issued.
My lord, no memorandum has been issued whatsoever. My case also was forwarded and regularized.
No, after the second cabinet approval.
No further memorandum.
So what do you mean by the second cabinet
my
approval?
lord, lordship may kindly see the orders, then lordship will.
Which order?
Page 94, by which I have challenged.
Yes.
In pursuance of the government approval order dated 5/6/2010, the service of the 18 teachers listed in Annexure A who had completed 10 years of continuous service as on 16/1/2004. My lord, this is important. So they are relating back to the memorandum by this date. Are hereby regularized under the following terms and condition. The effective date for regularization will be with effect from the date of cabinet approval, that is 18 May 2010. The past service will be counted for all other benefits such as increment, leave, pension. The industry seniority will be fixed in order the date of joining the post as a graduate teacher. Then lordship may kindly see next page. My name appears at serial number 6.
So what is this cabinet approval 18 May 2010? Any document?
My lord, government did not annex any document in their affidavit, except to say that lordship may kindly allow me to refer to the government's affidavit.
One way they have taken your service, continuous service.
Yes.
As on 16/1/2004. On the other hand, they say that regularization will be effective from 2010.
Yes.
Because of cabinet approval.
Yes, my lord, 269 paragraph, page 269. Paragraph 5. May I read, my lord?
Yes.
That with regard to the statements made in such and such, the state respondents submitted 183 teachers were regularized by order dated 30/11/2006 solely on the basis of their eligibility criteria contained in the OM dated 18/2/2004, and the effective date of regularization will be determined fixed from 16/1/2004 with the approval of the government cabinet. Whereas in the instant case, the petitioner could not qualify the criteria set in the OM dated 18/2/2004. Therefore, the petitioner, having failed to do so, cannot claim sick parity as he similarly circumstanced with those 180 regular teachers. As such, there is no question of negligence, arbitrary, or discriminatory action made out of the petitioner by the state respondents. The petitioner was not regularized till he was adjusted against a sanctioned post. Then, my lord, lordship, may kindly allow me to read paragraph 4. Paragraph 4.
Page number
267. That with regard to the statements, the state respondents specifically submit that the petitioner was initially appointed as an assistant teacher on ad hoc basis by 12/3/1993, which was not a sanctioned post on account of transfer of Mr. N.D.'s Shitri assistant teacher transfer to government Chonlika, but resulting in need for a replacement in government middle school. Further, it is admitted that petitioner was not appointed through any open advertisement, but appointed only on ad hoc basis as a stopgap arrangement in view of the requirement of GMS Tanhai at that particular period of time. The petitioner cannot mislead the court by cancelling facts without challenging the basic order, appointment order, but challenging consequential order. The state respondents submitted that as stated in memorandum dated 18/2/2004, which is also annexed in the petition. In category 1A, the regularization of service of ad hoc contract employees having more than 10 years of service was for those ad hoc appointments made against sanctioned vacant posts. As a settled proposition of law, service regularization is strictly done as per the government standing order policy. Hence, the petitioner cannot claim something as a matter of right, which is in contradiction of the government. The memorandum is not applicable to the petitioner as he was not appointed against a sanctioned post. Therefore, submission of his initial appointment order requisite educational qualification, performance, length of service increments does not satisfy the criteria for regularization contained in OM dated 18/2/2004. So the basic contention is that I was not appointed, initially I was not appointed against a sanctioned post, so I was not considered eligible and not considered, and when they were able to adjust a vacancy, I was considered. However, my lord, at page 81, I'm repeating again, 3A1, there is a sanctioned post. It does not say the petitioner should be holding a sanctioned post. Now, my lord, page 84. Lordship, you can see the page 84. My lord, this is to the Director School Education submission of original documents in respect of ad hoc teachers under TIS, Deputy Inspector School, MON. With reference to your letter dated 24 May 2004, I have the honor to submit here with the original documents in respect of ad hoc graduate teachers under the establishment of TIS duly filled the performer for 5 years and above ad hoc graduate teachers for regularization of their service. Then, my lord, at next page, serial number 110. Page 85. My lord, the type copy is also available from page 87 onwards. Page 88 will. Now, my lord, at page 85, it is legible. So, lordship, kindly allow me, serial number 11. Rakesh Ranjan, MSc B.Ed. Then, my lord, date of initial appointment 14/3/93.
Yes, 12/3.
Yes, 12/3, but 14/3/12/3, my lord, 4 years, 10 years. I qualified by 16/1/2004. By 16/1/2004, I have more than 11 years of service. So, my lord, my case was recommended by the controlling officer, having been found that I'm qualified in terms of OM 18/2/2004. If I'm not qualified, the controlling officer would not have recommended my case. Then, my lord, lordship may kindly come to page 92.
Now, why this date is not similar? 12, your date of appointment is 12/3.
Yes,
They've taken 14/3. Is
My
it
lord-
because your date of joining was 14/3?
my lord, I joined the next date. It must be a typing error, 1 or 2 days. I joined the next date. On 13, I made a categorical statement with my petition.
That joining report is not there, isn't it?
It should have been 13/3, Lordship.
No, you don't have a joining report next in the.
My
petition.
lord, I have got, that was, my lord, more than 30 years, but I only make a statement.
Okay.
But my lord, 12/3, 14/3 doesn't make any difference because it's the only question of whether I have 10 years of service, qualifying service as on 16/1/2004. By 16/1/2004, I have more than 10 years. Now, my lord, in 92, in case of other teachers who have similarly situated of 10 years, my lord, initially, my lord,
You were showing me as 84, page 84, 85.
yes,
Submission of original documents.
yes,
This is for the purpose of regularization.
yes, my lord, Lordship, may kindly see page 84.
Yes. So what happened to this?
My lord, my case was also forwarded at that moment of time in the year 2004, along with others.
Okay.
Now people, my colleagues who has been forwarded along with me, you're all regularized and I was left out.
Hmm.
That is the issue.
Okay.
Then, my lord, Lordship may kindly come to page 90.
90.
Initially, my lord, those who had completed 183 teachers who had completed 10 years as on 16/1/2004, government took a decision to regularize them with effect from date of joining of service. That last line, with effect from date of joining into service, the last line, last fourth line from on the top. Hereby regularized with effect from date of joining service.
What is this? This is as per the.
No,
This
my lord,
memorandum.
I'm showing you how they took the decision. My lord, initially for other 183 teachers who had completed 10 years of service as on 16/1/2004, government took a decision to regularize them with effect from date of joining in the respective service. Which was subsequently superseded, but I'm showing you the process, Lordship. This was the first order passed. How they took the decision, and initially in 2006, the decision was to regularize them from the date of joining. Then, my lord,
No, this has a bearing of 16/1/2004 as well.
I'll show you, my lord.
That is why
Subsequently,
it must be relating to the.
my lord, this has got a bearing of what has happened, Lordship.
Hmm.
Initially, government took a decision that you should be regularized with effect from date of their initial appointments. Then secondly, they took a decision that the second is, my lord, so this is the first order.
Okay.
Then, my lord, your lordship may kindly come to page 92. My lord, it will clearly show the arbitrary action. Now, my lord, department event number dated 30th November stands cancelled in pursuance of the letter dated such and such. The following 183 teachers who had completed 10 years of service as on 16 January 2004 includes hereby regularized with effect from 26/10/2006. This is the clearance of BNR and dated 26 June 2006, concurrence of Finance Department and Cabinet approval, that is on 16/10/2006. So it was superseded. The first order was superseded, and they took a decision that though they were completed on 16/1/2004, their regularization should be from 26/10/2006. That is the date of approval by the cabinet. That was the second order issued. Then lordship may kindly see the next order, page 93. Then they decided to revert back. Then a corrigendum was issued. In partial modification of the regularization of 183 teachers by 27/5/2005, the effective date of regularization of service may be read as 16/1/2004 instead of 26/10/2006. So, my lord, 3 orders were issued for those 183 teachers who had 10 years of continuous service as on 16/1/2004. First, my lord, from the date of initial appointment. Second order was from the date of cabinet decision, and thirdly, from the date of the date of decision by the cabinet to approve the policy, 16/1/2004. Now, my lord, now coming to my order at page 94. It is with effect from 18 May 2010, that is the cabinet approval. My lord, this is similar. My order is similar. This is similar with page 92 for the others, which was subsequently superseded by the corrigendum. My lord, here also, the second order supersession order was cabinet approval with effect from 26/10/2006. And this was subsequently superseded by corrigendum in 93. That is with effect from 16/1/2004.
There's one line here at page 93.
Yes.
From the top, the third line, reference number so-and-so, so-and-so, dated 27/5/2007.
My lord.
What is this? 2007.
My lord, this must be.
So there was another order.
Yes.
Pursuant to this order, 14 May 2007.
But the operative issue, lordship, is that effective date. My lord, I'm only concentrating on the effective date.
No, I understand. I understand. So,
Yes.
So apart from this second order of 14 May 2007, there was.
My lord, I don't
there
have that.
was-
I
there
don't have
was-
that.
There may have been some other order.
I don't
because-
have that document with me, nor the respondent annexed it. Now, my lord, thereafter, page 93, he decided to stick to 16/1/2004, that is the approval of the policy by the cabinet. Now, my lord, in case of the petitioner at page 94, it is similar with the order at page 92.
They've taken the cabinet approval.
Yes, so here, but which is subsequently superseded by the corrigendum at 93.
But not in your case.
Not in my case. So, my lord, thereafter, my lord, I have submitted my representations. My lord, it is there. Then, my lord, coming to.
Since when?
My lord,
2010.
immediately next page, 96. I submitted my representation of 15/9/2010, page 97.
Yes, this is the first representation.
Yes. Then, my lord, my confirmation of service at page 98, I was confirmed in service. Then, my lord.
Just a minute. Your serial number.
My serial number at 1, 2, 3, 4, 5.
5.
Serial number 5.
With effect from?
With effect from, my lord, with effect from 5/7/2012. Then, my lord, at page 101, in the month of March, 10 March 2022, the persons who had 5 years of service, you were also regularized with effect from 16/1/2004. Page 101. Page 101, my lord, type copy, 10 March 2012, my juniors. This is with regard to my juniors who had completed 5 years. Then the seniority list. Then, my lord, at 141, my second representation, 11/10/22. Then, my lord, my third representation my lord, at page 143 on 18/3/2023. Then the forwarding letter by the director at 145. And a seniority list was issued on 18 March 2023. My name. Thereafter, lordship, the rejection order, my lord, which.
Your name is at?
My lord, kindly allow me, permit me to show that.
What is the name of the petitioner?
My lord, I have noted down the number. I'll
Rakesh-
give you.
Rakesh Ranjan.
My lord, kindly bear with me, kindly. Sheeting promotion, MS.
This is
970. Page 138. 138, 970. But I have not I'm not challenging this, I have not impugned this seniority list. Just to show that a seniority list was issued where my name appears at serial number 970, wait, page 138.
This is a senior list of graduate teachers.
Graduate teachers. As on 9 November 2022.
Then what
No,
is this?
4th April 2023.
What is this, page 146?
My lord,
Officiating promotion.
yes, and officiating promotions were given on 18 January 2023 to those above my list. But I am not challenging the promotion orders in this case.
You're not
Just-
here, you're not promoted.
I'm not, because I'm below. Unless my seniority is restored, my lord, I'm down below at 870. Now, my lord, thereafter, my lordship has seen the two orders which was, my lord, (278) is a rejection order which lordship has seen. Just to complete the sequence, I'm only showing. 278, during the pendency, my lord, my representation was, during the pendency of the writ petition, the representation was rejected on 10th of October 2023. And my lord, 282 is for a direction for recovery of the MSCP. Now, my lord, so that is with regard to the facts of the case. Now, my lord, under 3 grounds. My lord, kindly allow me page 26, Roman 4.
Yes.
For another single judge had miserably failed to appreciate the fact that appellant have a superior claim over his juniors who have completed 5 years of continuous service and ad hoc as on 16/1/2004 and who were regularized with effect from 16/1/2004 by the order dated 10/6/2012, thereby superseding the appellant. Now, my lord, the 3 grounds, my lord, the learned single judge has framed 3 issues, and on the basis of which, paragraph 19, the case was dismissed. Now, on the first submission, my lord, now I'm coming to my submission. My lord, I'll try to.
Yes.
I'll try to be brief on the submission because your lordship has seized of the has get a sense of the issue. Now, my lord, on the issue of a sanction post, the government's stand was that I was not appointed against a sanction post, and that's why I'm not qualified. And learned single judge has wrongly accepted that contention, that submission. My respectful submission, my lord, the office memorandum clearly shows it only says it only talks about availability of a sanction post. The only issue is to determine who had qualified 10 years of service on ad hoc or contract, and thereafter, on the basis of seniority, he should be regularized. And it is a blanket decision. People who had completed 10 years of service as on 16/1/2004, if there are sanction posts, will be regularized. Lordship may kindly appreciate this fact that on 16/1/2004, besides those who had completed 10 years of service, there were also others who had completed only 5 years of service. Continuous service as on 16/1/2004, it clearly shows that there were vacancies available. Because subsequently, those 5-year service were regularized with effect from 16/1/2004 by an order of 2012. Whereas I was regularized in 2010 by the impugned order. So that is my first submission. Secondly, lordship, the different yardstick being applied. The 3 orders I have shown to your lordship. For others, initially it was initial appointment. Thereafter, the second condition was the date of decision by the cabinet, and which was superseded by corrigendum in 16/1/2004. But in the case of the petitioner, it is date of cabinet decision, not 16/1/2004 in terms of the government policy. Now, my lord, secondly, what is the subject matter of the case? My lord, my respectful submission is the subject matter of the present case is not about seniority in promotion. The learned single judge has wrongly held that it is about seniority in promotion and third-party interests are involved. My lord, I'm reiterating. My lord, can you allow me to submit two judgments on this issue? My lord, 1974, 4 SCC 335, paragraph 2, 11 to 15, 22, 23, and 37.
Please repeat the paragraphs.
Oh, why did I bring it? Lordship, instead of 74, I brought 1976. Kindly allow me to collect one from the library, then I'll read. I'm sorry. 1974, 4 SCC 335.
Paragraph numbers?
Paragraph numbers 2, 11 to 15, 20 to 23, and 37. My sincere apology.
You can read
Well,
this. You read this. We'll listen to you.
I'm sorry, my lord. It's a little. Well, hurriedly putting. Yes.
They have kept our chairs quite apart.
I'll read loudly, my lord. Let me read. Let me read loudly.
We should sit more closely.
Yes. There is no more COVID. My lord, I'll read. I'm reading, my lord. This civil appeal under Article 226 of the Constitution in the High Court for issue of writ of mandamus directing the present appellant, the General Manager, South Central Railway, and the Secretary Railway Board to fix the inter-se seniority of the writ petitioners as per original proceedings dated 16 October 2052 at the Railway Board, and to further direct them not to give effect to the subsequent proceedings dated such and such by way of modification and clarification. Then, my lord, I'm reading paragraph 11. Mr. Sangi, learned counsel for the appellant, has raised two preliminary objections. The first is that the writ petition was filed 8 to 11 years after the issue of the impugned decision, as such was liable to be dismissed, and the score of laches alone. The second is that writ petitioners did not implead about 120 employees who were likely to be affected by the decision in this case. Those employees proceeds, the argument were necessary. Those employees proceeds, the argument were necessary parties, and their non-joinder is fatal to the petition. Paragraph 15. As regard to second objection, it is to be noted that the decision of the Railway Board imbued in the writ petition contained administrative rules of general obligations, regulating observation in the permanent department, fixation of seniority pay of the employees of the erstwhile crane shop department. The respondent petitioners are impeaching the validity of those policy decisions on the ground of being violative of 14 and 16 of the Constitution. The proceedings are analogous to those in which constitutionality of a statutory rule regulating seniority of government servant is assailed. In such proceedings, the necessary parties to be impleaded are those against whom the relief is sought and in whose absence no effective decision can be rendered by the court. In the present case, the relief is claimed only against the railway which has been impleaded through its representative. No list or order fixing seniority of the impugned petitioners vis-a-vis the particular individuals pursuant to the impugned decision is being challenged. The employees who are likely to be affected as a result of the readjustment of the petitioner's seniority in accordance with the principles laid down in board decision of 16 October 52 were at the most proper parties and not necessary parties, and their non-joinder could not be fatal to the writ petition. Yes. I'm highly obliged, Lordship. Hurriedly, Lordship, well putting. I brought the wrong.
What you're stressing on is that they are not necessary parties.
They are not necessary.
They may be proper parties,
My
but
lord,
they are not necessary
yes,
parties.
because the learned learn a single judge has rejected the petition on the ground of third party interests.
No, but what will happen, supposing today they readjust your position way back from 2004?
Yes.
Then the entire slot between 2004 to 2010, they'll fall behind you.
My lord, the issue is this. My lord, this case, the case that I am filing is similar. Here, my lord, because of the wrong application of the principle, regularization principle, 120 juniors superseded him in the seniority list. So preliminary objection was taken that necessary parties were not implicated, that 120 persons were not, who are above him in the seniority list has not been implicated, nor the seniority list and promotions were not challenged. If your lordship may kindly read the subsequent judgment, paragraph which it is there, I have not read. It says that seniority has to be rectified with consequential promotions. The judgment is very clear. I have read only one up to 15. My lord, lordship may kindly take the trouble to read the remaining paragraphs. So the Honorable Supreme Court says, it is not the subject matter is only about the principles. Wrong, the policy of the government, wrong application of the policy is challenged. So in that situation, my lord, it is not necessary to implicate others who may be necessary, who may be proper parties, not necessary parties. Because here, my lord, in this particular judgment, which I have cited 74, he did not challenge the seniority list, nor the promotions. Because, my lord, till my seniority is restored, my lord, till my seniority is decided, whether I have any locus to challenge the seniority list and the promotions. That also has to be, because, my lord, that has to be, because first, my lord, the principle, under what principle I am entitled, that has to be decided. Now, in my respectful submission in the present case, the office memorandum, a different yardstick was applied to me. And, my lord, the decision-making process which I have shown is very obvious that it is totally discriminatory against me in clear violation of 14 and 16. So, my lord, the subject matter of the present case is only about the principle, wrong application of a different yardstick other than provided under the memorandum, which is in violation of 14 and 16. That much I'm challenging at the moment.
Okay, I understand. What you're basically saying is that in respect of your case, the reference which should be taken into account is the cabinet decision, which has been published through the office memorandum.
Yes.
In the cited case of yours, what is to be considered is the policy decision of that board, of the
Yes.
railway board.
Yes.
So going by that, who may fall ahead or below doesn't matter, because a reference is made to the decision made by the board or decision of the cabinet.
Yes.
So for that reason, you need not implicate anybody.
Yes. Now, my lord, I'm submitting another judgment, on similar line.
Because even if they have a grievance, ultimately, whom you supersede eventually because of the rectification.
Yes.
It will not be a legitimate grievance. Because they also have earned their place on the basis of the policy decision of
Yes.
the government.
Yes.
That is the cabinet decision.
Yes. So my respectful submission is that, my lord, those issues will be, my lord, first this issue has to be decided. Thereafter, my lord, if they become necessary parties thereafter, if they become aggrieved thereafter, then they can challenge. That is a different issue. But now, my lord, my date of regularization is 2010. Now, accordingly, my seniority is at 870. My lord, on the basis of a different, and my lord, 2 yardsticks were applied for others in terms of the policy, 16/1/2004, not the subsequent cabinet approval. In my case, not 16/1/2004, the initial decision of the policy decision of the cabinet, but the date of approval of the cabinet when our case was put off consideration for final approval after the process. So 2 different yardstick has been followed. That is why, my lord, I'm challenging that only. Subject matter is confining to them only. I'm challenging the arbitrary discriminatory action of the interpretation of the policy. How come two yardsticks, two different yardstick has been applied while regularizing the similarly situated persons, including my juniors, 5 years. Now 5 years has gone ahead of me. So, my lord, my respectful submission is that I'm solely banking on the due judgment of the Honorable Supreme Court. That is why I'm saying they are not necessary parties, they are only proper parties. And in the light of the judgment, if any grievance issue raised, that will be a different subject matter.
Where is your regularization? Is it page 94?
Lordship, yes.
And those who are regularized along with you?
Yes, it is also there, 95. But they did not approach this honorable court. Only the petitioner is approaching.
Those who are regularized with you, they have been appointed in the year 1982, 87, 1990, 91.
Some of them, many of them has retired by now, Lordship. Most of them already retired.
So what do you gain if you are given that 2004 effective date?
My lord,
you gain seniority, you will gain promotion, consideration for promotion.
My prayer is that I should be also regularized with 16/1/2004 with all consequential benefits. So the seniority and promotion will come because, my lord, if your lordship may kindly see that subsequent order paragraphs of the judgment, it talks about reflection of the seniority and consequential benefits to the petitioners.
This judgment.
Yes, because for time constraint, I did not read the relevant paragraph from paragraph 20 onwards. Now, my lord, another judgment where 74 judgments was reiterated. 1983, 3 SCC 601. Now I'm getting the right one.
(1983).
Yes.
Volume
3, 601.
Paragraph?
My lord, paragraph 36 and 37.
This is on
the same, where, my lord, the judgment which I have referred was reiterated. Married, two paragraphs. Page 625. Married, my lord, paragraph 37, 6. Paragraph 36.
You got it, brother?
Yes.
625, yes.
Paragraph 36. It was contended that those members who have scored a march over the appellant in 1974 seniority list, having not been impleted as respondents, no relief can be given to the appellant. In the writ petition filed in the High Court, there were in all 418 respondents. Amongst them, first two were Union of India, Engineer-in-Chief, Army Headquarters. In the list, presumably must be those seniors shown senior to the appellant. By an order made by the High Court, a name of respondent 3 to 418 were deleted, since met notices could not be served on them on account of the difficulty in ascertaining their present address on their transfer subsequent to filing of those petitions. However, it clearly appears that some direct requests led by Mr. Chit Kara appeared through counsel Sachin Rao and made the submission on behalf of the direct recruits. Further, an application was made to this court by 9 direct recruits for being impleted as parties whose application was granted, and PR Monital Learned Counsel appeared for them. Therefore, the case of the direct recruits have not gone unrepresented, and the condition can be negative in this ground. However, there are some cogent reasons why we would not countenance this contention. In this case, appellant does not claim seniority over any particular individual in the background of any particular fact controverted by that person against whom the claim is made. The contention is that criteria adopted by the Union government in throwing up the seniority list are invalid and illegal, and relief is claimed against the union government, restraining it from upsetting or quashing the already thrown up valid list or for quashing the impugned seniority list. Thus, the relief claim against the union government and not against any particular individual. In this background, we consider it unnecessary to have all direct requests to be implemented as respondents. We may in this connection refer to, so this is a judgment which we have cited, repealing a condition on behalf of the appellant that the writ petitioner did not employ about 120 employees who were likely to be affected by the decision in the case. This court observed that in paragraph 15 that I have read, my lord, the respondents, original petitioners are impeaching the validity of those policy decisions on the ground of their being violative of 14 and 16 of the Constitution. The proceedings are analogous to those in which the constitutionality of a statutory rule recording seniority of government servants is assailed. In such proceedings, the necessary parties to be implemented are those against whom the relief is sought and in whose absence no effective decision can be rendered by the court. Approaching the matter from this angle, it would be noticed that relief is sought only against the Union of India and the concerned ministry, not against any individual, nor any seniority is claimed by any one individual against another particular individual. And therefore, even if technically the direct request were not before the court, the petition is not likely to fail on that ground. The convention of response to this reason must also be negativate. The appellant is also saw the direction for quashing the penal promotion order that such and such included in such and such on ground that the penal for promotion is thrown on the basis of impugned seniority list and which appellant is severely situated promoted way back in 62 onward did not find their place and were therefore not treated as being within the zone of selection. This relief must follow as a necessary corollary because once 1974 seniority list is quashed and consequently a declaration is being made that 63 and 70 seniority lists were valid and cannot be at a no by a principle of seniority determined in 74, any penal thrown up on the basis of the invalid seniority must fail and must be quashed. Pursuant to an integrated reading of the judgment in Bachchan Singh case, in this case, a fresh panel for promotion will have to be drawn up consisting with the seniority level of 63 and 67 before it was not disputed about the promotion of the cadre for executive who appeared in the competitive examination of 1976. One engineer is in the principle of seniority cum merit. It will be mentioned that the appellant has sought interim relief, such and such, my lord. This court declined to grant such relief because exigencies of service demand of vacancies have to be filled. But in order to protect the interests of the appellant and two similarly situated, it was made abundantly clear that any promotion given to subsequent of the date of filing of the petition in the High Court must be temporary and must abide by the decision of this appeal. Therefore, consequent upon relief being given in this appeal, the promotion will have to be readjusted. In the case of the appellant, and a similar situation will have to be examined for being brought on the panel of promotion. My in the similar line, Lordship will see in the 74th. My lord, kindly allow me to read from paragraph 20 onward, the 74th judgment. Yeah. Paragraph 20. My lord, the 74th judgment, which the first one. Page. My lord, I'm relying on AIR. So page 20, paragraph 20.
How does it begin? The fundamental right.
As regards the second objection, paragraph 20, Lordship. 20.
74.
Yes.
Volume 4, SEC.
Yes.
335. Your para 20 and my para 20 is not similar. It begins the fundamental right of equality. How does it begin yours?
My lord, as regards the second objection.
As regards the second objection. That is AIR, isn't it?
Yes, I'm reading from AIR.
The paragraphs are different. This is the problem.
Para 15.
13.
Not para 15.
15. Yes, it's para 15 here.
As regard the second objection, it is to be noted that decisions of the regular board imbued in the writ petition contain administrative rules of general application, regulation, absorption in permanent department, fixation in seniority, pay and such. The respondents are impeaching the validity of those policy decisions on the ground of their being violative of 14 and 16 of the Constitution. The proceedings are analogous to those in which constitutional of the statutory rules regulating seniority in government servant is assailed. In such promotion, the necessary parties to be implemented are those against whom relief is sought and in whose absence no effective decision can be rendered by the court. In the present case, relief is claimed only against the railway, which has been implemented through the its representative. No list or order fixing seniority of the petitioner's service particular individual pursuant to the impugned decision is being challenged. The ambulance who are likely to be affected as a result of the readjustment of the petitioner's seniority in accordance with the principle laid down in the court decision were at the most proper parties and the necessary parties, and here non-joinder could not be fatal to the writ petition.
Mr. Takamasa, kindly wait.
Yes.
You attend to that one matter. You attend to that
Requested it. That's all. May I please, Your Lordship, since my other colleagues are waiting, since more, may I pray that this matter may continue tomorrow? If we constitute in the first half, so that we, at the stage, we conclude the matter, because it will not take much time now. But for the respondents to respond also, my lord, but the interest of the others also, my lord.
No, but how many matters are there still? Let's see.
My lord, we are serial number 2. 7 more matters are there.
7 more matters are there.
They are waiting, so it won't be fair if I.
No, but these are what hearing matters. These are orders.
Yes.
Isn't it?
Lordship, mine is order matter, Your Lordship. And
So, my lord, let your matters be taken up at 2, then thereafter we continue. But after single bench.
no, Your Lordship, here I have taken the steps and then service reports still waited as per the.
Orders matters will not take that much time.
No,
Yes.
See,
May I pray that those other items be taken up first, then we continue thereafter?
if it's not a hearing matter, we can take up the other matters, then we
Yes.
can continue with this.
Yes, Lordship. Yes, Lordship.
My lord, there is one matter.
Sorry?
Hearing one fixed matter.
Yes, who are the parties?
We are all ready, my lord.
Item 14.
Yes.
But since we're in the midst of this hearing already, so we should complete this. Isn't it? Subject to time, we'll take it up, subject to there being time, because Mr. Takamasa will complete his thing, then government advocate will again submit his part. So it might take a while. And I believe my brother has one matter also.
Then-
Okay, we'll come back in the afternoon. First, we'll deal with the order matters and all that. We complete that. And except for the hearing matter.
Yes.
Hearing matter, we'll have to wait because we want to complete this. We'll complete this, then if some time is still available, maybe we can take up the hearing matter, the other hearing matter also. All right?
Okay.
ঠিক আছে জায়গা বাবা দুই ঘন্টা করবি আজকে কি খায় Oh, yes, yes, yes. Yeah, What's the name? What's the team? What's the hero? I suggest so. Salah. I have no connected. I is I Commissioner Secretary was covered under that. Oh, personal. It's a personal. Aí ela chegando procedure means to have as a lot very careful. So this code Who find a
Sure.
For admission, item number 6.
May it please Your Honor.
Yes.
Your Honor, here, after the last date when notice was issued, I was issued an order by which my detention had been revoked, and therefore this petition has become infructuous. So kindly grant me the liberty to withdraw this.
Give me that order.
I was detained under the NDPS.
What is your good name?
Alizo Kire. My accused person's name is Atole Kent.
Please write down. Mr. Alizo Kire, learned counsel for the petitioner, submits that pursuant to the moving of this petition on 24/7/2024, the detainee has been released.
Yes, my lord, my representation was acceded to, quote unquote. In the third paragraph, it says, my representation was considered and acceded to.
After favorable consideration of the representation filed by the said person by the order dated 27/2024. Stop. He therefore submits that the petition has become infructuous. Mr. E. Tivapon, learned
Appearing for respondent number 1, 3, and 4.
counsel for respondent numbers 1, 3, and 4, and Mr.
Respondent number 2.
Your good name. Z. Z.N. Muli, learned counsel, appearing for respondent number 2, agrees to the submission made by the learned counsel for the petitioner. Next para, in view of above, the writ petition stands disposed of as infructuous. Order dated 27/2024, produced by the learned counsel for the petitioner, shall be kept on record and marked as X for identification.
I'm obliged, my lord.
Much obliged.
For admission, item number 7.
May I please, your lordship?
Ah.
Here I'm yet to receive instruction. So kindly allow me 2 weeks time, my lord.
You had made that prayer in the morning, isn't it?
Yes, my lord. The special secretary, she was out of station, so she's returning this week. So within 2 weeks, I'll file the affidavit.
What about notice? It's complete.
Yes, my lord.
Yes, sir. Yes, my lord.
Mr. Muli and yourself, you are there.
Yes, please.
Okay.
Yet to receive instruction, madam.
How much time do you require?
2 weeks.
2 weeks.
No, my lord, this is a habeas corpus petition. Can be taken this Friday, if possible, my lord.
Without instruction, how do we take up the matter?
My lord, basically here, my contention is main contention is 2 grounds, my lord. Whether the central government has considered my representation or not, and whether the advisory board has considered my representation or not.
We'll have it on Wednesday. By then you get instructions
Next
from your
Wednesday.
source. Yes, coming Wednesday.
Optimal.
All right.
No.
Learned counsel for the respondents pray for further 2 weeks' time to obtain instructions. To stop, counsel for the petitioner vehemently objects to the prayer, stating that the detainee has been illegally detained. To stop, considering the submissions made, list the matter again on 28th of August 2024. To stop, respondents should get up-to-date instructions by then.
Obliged, my lord.
For admission, item number 8.
My lord, similar prayer for item number 8. my lord.
Same party?
Yes, my lord.
Yes, same party.
Similar order. Similar order.
Much obliged.
Obliged, my lord.
For admission, item number 9.
Yes, this is also
Lordship,
Detention.
here, however, I'm yet to receive the service copy from the petitioner counsel.
Where's Mr. Supongwati? He was here this morning, I think. Mr. Supongwati Walling.
Lordship, in that view of the matter, Lordships, if this matter can come up after 3 weeks, Lordship, I'm yet to receive the service copy from the petitioner counsellors. The notice of motion was issued on 8/8. Lordship.
Similar prayer, my lord. I have not received the prayer for the from the petition.
Mr. V. Zimomi and Mr. Z.N. Muli, learned CGC, appearing for the respondents, submit that they have not received the service copies of the petition till date, and therefore they are unable to obtain instructions in the matter. None appears for the petitioner when the matter is called. Full stop, as paid for. This is the matter again after 2 weeks. Yeah.
3 weeks.
Why?
We had to make a correspondence.
You make,
After receiving the paper.
you pray for extension of time, not 3 weeks as a stretch, 2 weeks. Counsel for the petitioner shall serve adequate copies of the petition to the learned counsels appearing for the respondents within 3 days.
For orders, item number 11.
Lordship, I have filed an IA
For
implement of the new incumbent. That is, my lord,
incumbent, which post?
Commissioner and Secretary.
What is the name?
Sri Y. Kiketo Sema IAS, the Commissioner and Secretary, Department of Law and Justice, Nagaland, Kohima. He has recently taken over as the Commissioner and Secretary, Lordship.
But he's already number 4.
Yes.
Why did you put him in number 4?
Previous other 3 also transferred out,
You are asking for impleadment.
Lordship.
That prayer is yet to be allowed.
Lordship.
In the cause title, you have already arrayed him as the number 4. What remains to be allowed?
Lordship, the first one is at,
Have you understood?
yes,
The regular parties will be there. Petitioner, respondent 1, 2, 3.
Lordship.
So you want to implead one more person, that should be kept separately. That please implead this person as number 4. We allow, then you put them in serially 1, 2, 3, 4. Now you have already put them in serial term 1, 2, 3, 4.
Lordship, in the previous occasion.
Okay, anyway, we'll allow. Anyone,
Lordship,
any objection? Nobody from the other side?
No, they have
Okay.
already consented.
Heard Ms. Z. Zimami, learned counsel for the applicant, who submits that the applicant, by filing this application, seeks impleadment of Shri Y. Chiketo Sema,
Yes, Lordship.
IAS Commissioner and Secretary, Department of Law and Justice, as respondent number 4
Lordship.
in the contempt petition. Since the earlier incumbent has been replaced by the said person, to stop. She submits that impleadment of the new incumbent is necessary for effective compliance of the court's direction.
Yes, actually, the case is fixed on 23/9/2024, the main contempt petition. But this is for,
Next para, in view of above, upon perusal of the application and upon hearing learned counsel, the prayer for impleadment of Sri so and so is hereby allowed. IAS stands disposed of. Then in the main contempt, you write, in view of the order passed today in IAC number 113 of 2024, Sri so and so is hereby impleaded as respondent number 4.
Lordship, we will take
Just a
step
minute,
3.
just a minute. Stop. The counsel for the petitioner shall file the corrected cause title in 2 sets before the registry of this court within
3 days.
3 days.
We shall also serve
Stop.
notice to the.
Just a minute.
Lordship.
Stop. On submission of the corrected cause title, registry shall do the needful. Full stop. Next para. Issue notice upon the newly impleaded respondent number 4, returnable by 3 weeks. Stop. Petitioner shall take steps for service of notice upon the newly impleaded respondent number 4 by registered post with ADD within a period of 1 week. List the matter again after 3 weeks.
For orders,
Yes.
item number 12.
May I please, Lordship? Lordship, here I've taken step by registered post for service upon respondent number 7. If my lord may kindly see the office note dated 16/8/2024.
When did you take steps?
On 22/5/2024.
And from the registry, it went on 29/5.
29/5.
Steps was 22 perhaps.
Yes, I've already taken steps.
Talabana on 22/5,
Yes,
but notice went from the registry on 29/5.
okay.
Now we are in August. Now,
Lordship,
you are the petitioner,
Lordship appellant here,
petitioner appellant.
Lordship.
Who's respondent number 7?
Respond number 7,
Private respondent in
Lordship,
the writ petition.
Lordship.
What is the address?
The official address I've given your Lordship is the SI. Ma, I should.
Henley Kent is the one. Srimati Henley Kent.
Lordship. Care of DGP. The official address I've sent your Lordship.
We'll do one thing, we'll direct the registry to track it, postal consignment. Let it be tracked.
If your Lordship
or
may
you
kindly
want-
see the note, office note 16.8. Office note.
Okay, okay. Okay, delivered. It's already tracked.
In fact, your Lordship, before the read court, the private respondent, she did not contest also. Even the read petition, petitioners, they have taken, appellant has taken steps both by registered post as well as by Dusty. And the private respondent did not contest.
Okay,
And,
please.
and there was an application for condonation of delay in this appeal, your Lordship. We have taken both steps, both by way of registered post as well as by Dusty. That IA for condonation was also not contested, your Lordship.
Mr. Paul?
My lord, I'm appearing on behalf of V. Sokre, additional AG. She is not feeling well, so matter will be taken up next week, my lord.
So my prayer, Lordship, if the notice may be deemed to have been served, because read petition also before the learned single judge, the private respondent did not contest. And even here also, when the IU was moved for condonation of delay.
Okay, so please write. Office note dated 16/8/2024 indicates that AD card has not returned back from respondent number 7. Stop. However, it is stated that as per the postal track consignment, the notice sent to respondent number 7 appears to have been delivered to the addressee. Stop. Upon perusal of the track consignment. No, upon perusal, you cut that. Stop. Mr. T.B. Jamir, learned counsel for the appellant, submits that the respondent number 7, in fact, did not contest
in the connected read petition.
Did not contest before the learned single judge when the writ petition was pending. Similarly, the respondent number 7 did not contest the application filed by the appellant seeking condonation of delay in filing the writ appeal. He submits that therefore the notice may be deemed to be may be declared to be complete in view of the postal consignment, in view of the postal tracking done. Stop. Next para, in view of above, the notice upon respondent number 7 is declared to be complete. Stop. Mr. E. Tibafom, learned state counsel, submits that. Who's appearing?
I'm appearing for V. Sokre, additional AG.
Submits that Ms. V. Shukre, learned additional AG, who is handling the matter for the state respondents, is indisposed, and therefore matter may be adjourned.
1 week.
For
Next
a week.
week.
Next week, your Lordship.
In view of above, list the matter again after a week.
No, for admission hearing, your Lordship, this is a very short matter.
on, give the date, next Wednesday,
Next Wednesday
28th.
for admission hearing, Your Lordship.
For
Obliged.
admission.
Much obliged.
There's one more, no? Hearing.
May I please your Lordship?
Yes.
Lordship, before I proceed to the next point, next judgment, my Lord, now I have brought my book. So kindly allow me to.
Just a minute. This sound system is controlled somewhere. That ecosystem is there.
I see.
It is good when if somebody sings and all that. But for just conversation, that echo really affects us. Just find out. Yes. Yes, Mr.
My Lord, that 74 judgment, 1974 judgment, which we've just referred.
Yes.
My Lord, kindly allow me to read paragraph 37. Because that 1974 for SCC 335. I'll read only one paragraph. Page 348.
Yes.
My Lord, may I read?
Yes.
A mandamus, therefore, issue directing the appellant to restore and refix the place of Manik Yam in the list of seniority as on 31st December 1958 in accordance with the Railway Board's direction of October 16, 1952 in taking into account other relevant consideration, but ignoring the directions contained in the board's communication dated November 2, 1957 and January 3, 1961 to the extent they have been held to be unconstitutional and invalid. If, as a result of the refixation of his seniority as directed, Manik Yam becomes entitled to be promoted or to be considered for promotion, he shall be so promoted or considered for promotion on an actual and notional basis with effect from the date on which such promotion or consideration for promotion as the case may be falls due. So, my Lord, the query is raised by your Lordship. This Honorable Court, the Honorable Supreme Court went to the extent of giving that direction, but at the moment, in the present case, my only respectful submission is that I have not gone that far. My only prayer is that refix my seniority with all consequential benefits, that much. But I'm only, since the concern has been raised by your Lordship, I'm just highlighting the paragraph 37.
Yes.
Now, my Lord, on the issue of delay, because one of the grounds for rejection of the writ petition was that delay in latches in third-party interest.
Yes.
I'm only submitting. Now, my Lord, subject to repetition. We submitted representations. Then finally, the principal director by a letter dated 27/2023, page 277, which has been repeatedly shown. My case was forwarded, page 277.
Yes.
And
This is after the filing of the writ petition.
before filing, Lordship.
This is before filing.
Before filing. My Lord,
When did
the
you file
writ
your
petition was filed on 17/7/2023.
Okay.
Writ petition was filed on 17/7/2023. Notice was issued on 27/2023. Lordship, at paragraph 12, page 46 of the judgment, it is reflected. On which the notice was issued, Lordship, may kindly see page.
Notice was issued on? Notice.
Notice. 27/2023. 27/2023. 27/2023. 27/2023. 27/2023. 27/2023. 27/2023. 27/2023. 27/2023. 27/2023. 27/2023. 27/2023. 27/2023. 27/2023. 27/2023. 27/2023. 27/2023. 27/2023. 27/2023. 27/2023. 27/2023. 27/2023. 27/2023. 27/2023. 27/2023. 27/2023. 27/2023. 27/2023. 27/2023. 27/2023. 27/2023. 27/2023. 27/2023. 27/2023. 27/2023. 27/2023. 27/2023. 27/2023. 27/2023. 27/2023. 27/2023. 27/2023. 27/2023. 27/2023. 27/2023. 27/2023. 27/2023. 27/2023. 27/2023. 27/2023. 27/2023. 27/2023. 27/2023. 27/2023. 27/2023. 27/2023. 27/2023. 27/2023. 27/2023. 27/2023. 27/20 Notice was issued on 27, 2023.
27,
27,
oh,
2023.
20th July
Yes, 20th July
23.
2023.
17th you had filed.
Yes.
Okay.
Now, my lord, since the petitioner respondents were sitting over this forwarding letter, I approached this honorable court. Then, my lord, at 278, next page. During the pendency on 6 October 2023, my representation was rejected, disposed of, which lordship has gone through.
Do you have a copy of this letter? 24. Okay, this is the one which has been forwarded.
Which is forwarded is
Okay, yes.
27 to 28. To maintain continuity, I'm showing it both in the governance affidavit, lordship.
Yes.
In fact, lordship, in paragraph 6, this paragraph 6 of the writ petition at page 270, governance affidavit, this has been dealt with.
270.
270. But the statements are false. Because, my lord, in the last 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. 12 from the bottom.
In this regard?
Yes, it was only after a lapse of 12 years. My lord, this is factually incorrect. My earlier representation has not been reflected by my earlier representation from 2010 onwards has not been reflected in the affidavit, but to show that they are admitting the fact that it was disposed of, forwarding letter was issued, then it was disposed of on 6/10/2023 from the governance affidavit, lordship. So, my lord, my respectful submission is submission of my representations. After submission of my representations, my lord, it was forwarded and you were sitting over it. And finally, it was disposed of on 16/10/2023 during the pendency of the writ petition. So in that particular facts and circumstances of the case, my lord, there's no delay. I'm making a submission, my lord, that though my imbued order was issued, the imbued order was issued as early as 2010. Since the representations were forwarded and disposed of during the pendency of the writ petition, there is no delay in filing the present writ petition, so the petition should not be attracted by delay in lashes. That is what I'm trying to make on it. That is my submission, my lord.
Where is your first representation?
My lord,
is it page 97?
Lord, kindly bear with me. Yes, my first representation is page 97.
But what have you prayed for?
My lord, I submitted all my documents for reconsideration. My lord, I have been serving as graduate teacher post since 1993. All relevant documents in support my qualification is included. Therefore, you are fervently requested to look into the matter above and needed action for favoring my appeal. In short, my lord, by reflecting that I am appointed in 1993 under the scheme, I am left out. Maybe, my lord, representations may not be lengthy, but in short, some in substance. My lord, Billy School teacher from Mon. Then, my lord,
not just school teacher, science teacher.
Of course, he may not be very good in English. Then, my lord, at page 141 is the second representation.
Yes, 141.
My lord, the type copy is 142.
This is in 2022.
22.
After 12 years.
Yes. My lord, the type copy is 142.
Yes. 142. 142. 142. 142. 142. 142. 142. 142. 142. 142. 142. 142. 142. 142. 142. 142. 142. 142. 142. 142. 142. 142. 142. 142. 142. 142. 142. 142. 142. 142. 142. 142. 142. 142. 142. 142. 142. 142. 142. 142. 142. 142. 142. 142. 142. 142. 142. 142. 142. 142. 142. 142. 142. 142. 142. 142. 142. 142. 142. 142. 142. 142. 142. 142. 142. 142. 142. 142. 142. 142. 142. 142. 142. 142. 142. 142. 142. 142. 142. 142. 142. 142. 142. 142. 142. 142. 142. 142. 142. 142. 142. 1 You're mentioning about the seniority position.
My lord, seniority position, definitely, my lord, that is his understanding of the case that he superseded because his conception is that he is superseded. But then the principle is, my lord, the issue is he was not able to comprehend his grievance, but then the fact remains that he has submitted representations. Then, my lord, page 143. This is the representation which the government in their affidavit is referring to. The other two representation was not reflected in their affidavit. And thereafter, my lord, then thereafter 145 is the forwarding, which your lordship has gone through. But for convenience sake, I'm showing from the government's affidavit. Now, my lord.
Yes.
An argument may be taken that I have submitted my second representation after 10 years. There is no dispute about that. In that situation, if the government authority rejected my representation on the ground of lashes and delay, the matter would have been different. My second representation, lordship has rightly pointed out, was submitted after a gap of 10 years. Thereafter, in 2022, then in 2023, I again submitted my third representation. At that particular stage, if the director rejected my representation on the ground of lashes and delay, then I have no ground. I wouldn't have approached this honorable court. But the director was gracious enough, government was gracious enough, having realized my grievance, my case was forwarded. So a new lease of life in my respectful submission was given to me when my case was forwarded in the peculiar facts and circumstances, because you must have realized grave injustice was done to me. And since you were sitting over the representation, forwarding without any disposal, I approached this honorable court, and during the pendency, when this issue was raised, my lord, my representation was rejected. So, my lord, 2021, 1 SCC 804. I will refer only one paragraph, paragraph 17.
2021.
2021, 1 SCC 804. My lord, I'm reading paragraph 17 only.
Regarding delay.
Yes, in view of that the respondents were sitting over the file. On delay. Page 811. May I read, my lord? The aforesaid discussion therefore leads us to the conclusion that the writ petition was not barred by unexplained delay, as the appellant had been pursuing the matter with the authorities in EDST who said over it, triggering rejection of the appellant's tender by the Rajasthan government on 5/7/2019, leading to the institution of writ petition on 24/7/2019. The High Court therefore had erred in dismissing the writ petition on ground of delay. The illegality in this disproportionate nature of the order dated 8/9/2009 with no third-party rights affected, never engaged the attention of the High Court in the judicious exercise of the discretionary equitable jurisdiction. Consequently, the order is set aside. My lord, I'm reiterating that in the present case, there is no third-party interest because, my lord, it is not necessary to challenge the seniority list, and only the necessary parties are involved. Now, my lord, the learned single judge on the issue of delay had relied upon certain judgments. So, my lord, kindly allow me to go to paragraph 29, page 60 to the writ petition. Then I'll try to distinguish. My lord, the Honorable Supreme Court, learned single judge, may I read paragraph 29, page 60.
Yes.
In the backdrop of the said facts, the question arises as to whether there has been any delay or lashes on the part of the petitioner approaching this court, more so when the dispute was service-related dispute pertaining to seniority in not a pensionary dispute. My lord, the learned single judge has made a grave error by saying that disputes relating to is a dispute relating to seniority. That I'm aggrieved.
That is what you had stated in your representation otherwise.
My lord, the subsequent
earlier representations.
My lord, the subsequent representations of 2023, lordship may kindly see.
No,
Because
that is-
three representations I have submitted.
Correct, that we have seen.
Three representations I have submitted in the forwarding letters. Now, my lord, in the case of Darsim Singh, Supra, my lord, Darsim Singh is 2008, 8 ACC 648, 2008, 8 SCC 648. And relevant paragraphs is paragraph 7. It is quoted in the judgment. So, my lord, I'll read from the judgment. Not necessary from the, the learned single judge.
Yes,
but
yes.
the Supreme Court tells what is the continuing wrong and as to how a belated service related claim is to be dealt with. Paragraph 7 of the said judgment being relevant is reproduced herein under. Darsim Singh is a short judgment, my lord. My lord, the facts of the case about Darsim Singh is that it was the matter relating to an army invalid pension. He became invalid on 13/11/1983. Petition was filed in 1999. That is the subject matter of Darsim Singh. Now, may I read paragraph 7? Next page. To surmise, normally a belated service-related claim will be rejected on the ground of delay and lashes, where remedy is sought by filing a writ petition or limitation, where remedy is sought by application to the administrative tribunal. One of the exceptions to said rule is cases relating to continuous wrong, where service related to claim is based on a continuing wrong. Relief can be granted even if there is a long delay in seeking remedy with reference to the date on which continuing wrong commences. If such continuing wrong creates a continuing source of injury. But there is an exception to the exception. If the grievance is in respect of any order or administrative decision which related to or affected several others, or if the reopening of the issue would affect the settled rights of third parties, then the claim will not be entertained. My lord, I do not, in my respectful submission, I do not come within this category. For example, if the issue relates to payment or refixation of pay or pension, relief may be granted in spite of delay as it does not affect the right of the third parties. But if the claim involves issues relating to seniority or promotion affecting others, delay would render the claim stale and doctrine of laches limitation will be applied. Insofar as the consequential relief of arrears for past period, the principle relating to recurring successive wrong will apply. As a consequence, high courts will restrict the consequential relief relating to errors normally to a period of 3 years prior to the date of filing of the writ petition. So, my lord, in my respectful submission, since applying to the two judgments of the Honorable Supreme Court, my respectful submission is that there is no question of third party interest in the issue because I am not challenging any seniority, no promotion. So, my lord, the principle of Darsim Singh will not, the exceptions of Darsim Singh will not apply. In fact, the first part of continuous wrong will apply. Now, paragraph 30, learned friend, the Honorable Single Judge has talked about shift task, that is about pension, monthly to month pension. Then the third judgment he has referred, my lord, is about Chennai Metropolitan Water 2014 4 SCC, Chennai Metropolitan Water Supply. My lord, this case relates to willful absence from service. My lord, somebody who was willfully absent in service of more than 12 years approached this under the court. That is the facts of the case. So, my lord, in my respectful submission, my lord, the ratio of this judgment will not apply in the present case. That is what I'm trying to distinguish. Now, my lord, even worst comes to worst. My lord, I'm 2009 6 SCC 791, paragraph 20.
2009 6 SCC.
2009 6 SCC 791, paragraph 20. Let us presume, my lord, but that it makes that there is third party interest. I'm taking the worst position.
Yes.
Page 797. Merit.
Yes.
Paragraph 20. And MB versus Namdal Jaiswal, it was held as under. There can be no doubt that the petitioners were guilty of gross delay in filing the writ petition, with the result that by the time the writ petition comes to be filed, that if there is inordinate delay on the part of the petitioner in filing a writ petition, in such delay is not satisfactorily explained, the High Court may decline to intervene in ground relief in the exercise of its writ jurisdiction. The evolution of this rule of laches or delay is premised under a number of factors. Of course, this rule of laches or delay is not a rigid rule which can be cast in a straitjacket formula, but there may be cases where, despite delay in creation of third-party rights, the High Court may still, in the exercise of its discretion, interfere and grant relief to the petitioner. But such cases where the demand of justice is so compelling that the High Court would be inclined to interfere in spite of delay or creation of third-party rights would by their nature be few or far between. Ultimately, it would be a matter within the discretion of the court. Every discretion must be exercised fairly and justly so as to promote justice and not to defeat it. So, my lord, Honorable Supreme Court says that even in delay involving third-party interests, my lord, discretion is still with this Honorable Court to find out whether the gravity and the injustice. Now, my lord, I'm submitting a case on ratio. 2017 16 SCC 605 28 and paragraph 28 and 29. Page will be 626.
This is on ratio.
Yes, this is a ratio. That a decision is only an authority for what it actually decides.
It applies to you also.
That is what I'm saying. That is what I'm just, my lord, just 28 and 29. I need with para 28, 29. Just I did not say, I did not take the trouble of reading all the orders, but that order, my lord, is an accepted principle. Now, my lord, subject to repetition, on the issue of MSCP recovery. Yes. In the morning, my lord, I have made a submission that, but subject to repetition, since this is important, my lord, initially, my lord, subject to repetition, kindly allow me to make few submission here. My lord,
you may conclude by 3 o'clock.
Yes, this is the last point. This is the last repetition. That's why I'm saying repetition, my lord.
Yes.
Others are all completed, but MSCP, my lord, since it is important, I thought I should repeat once. My lord, granting of 10 years senior scale after completion of 10 years of service with effect from 1993. Secondly, granting of MSCP with effect from 16/1/2014, taking 16/1/2004. I took these two grounds as the basis to prove my substantive appointment. Now, my lord, in the affidavit in opposition, lordship has it was shown that, my lord, an order was issued at page 278, whereby, my lord, I was directed to recover my MSCP. 282, I'm sorry, 282, which lordship has gone through. So, my lord, I took this as a ground in my reply affidavit in reply for the first time, and this issue was dealt with. And, my lord, in paragraph 10 and as well as paragraph 13 of the judgment. Then a single judge has also discussed this issue, but he did not give any finding. So, my lord, even if the petition was rejected, even if my writ petition was rejected, my lord, the learned single judge, in all fairness, should have, my lord, applied the principle of 2015 4 SCC 334, paragraph 18. I'll only read this paragraph and I'm concluding. 2015 4 SCC 334.
Yes, paragraph.
Paragraph 18. Page 345. May I read, my lord?
Yes.
It is not possible to postulate all situations of hardship which would govern employees on the issue of recovery, where payments have mistakenly been made by the employer in excess of their entitlement. Thus, it may, based on the decision referred to here and above, we may ask a ready reference. Summarize the following few situations where recoveries by the employees would be impermissible in law. 1, recovery from employees belonging to class 3 and class 4 service. My lord, I come within that. Then 2, my lord, recovery from retired employees. It doesn't govern me. My lord, 3, recovery from employees when the excess payment has been made for a period in excess of 5 years before the order of recovery is issued. My lord, C, condition 3 will cover my case because recovery is to be made after much more. Then recovery in cases where employee has been wrongfully required to discharge duties of a higher post and has paid accordingly. Number 5, in any other case where the court arrives at the conclusion, the recovery, if made from the employee, would be iniquitous or harsh or arbitrary to such an extent as would far overrate the equitable balance of employer's right to recovery. So, my lord, condition 1, 3, and 5.
You belong to which class?
My lord, class 3.
Class 3.
Class 3.
Are you sure?
Yes. The next is assistant headmasters are class 2, lordship. Graduate teachers are class 3. But in any case, my lord, condition 3 and 5 also will come into play. Because condition 3 is recovery from employees when the excess payment has been made for a period in excess of 5 years before the order of recovery is issued. So, my lord, and also reiterating, my lord, AIR 1965, 1578, which I've referred, paragraph 17, that issues can be raised under an affidavit in a reply affidavit. So, my lord, whether the writ petition is allowed or dismissed on merit, this is a separate issue that may currently be taken into consideration. In fact, as a matter of abundant caution, in my prayer, in my writ petition, in my writ appeal, I have also made a specific prayer to quash and set aside the order, the letter. So, my lord, prayer number 4 at page 34 is the issue. Much obliged, lordship. And my lord, the IA, my lord, the IA is about the interim order not to recover during the pendency. So, my lord, now ultimately it merges with the main petition. Much obliged, lordship. I'm highly obliged for a very patient hearing, lordship. I'm highly obliged.
Yes.
May I please, my lord? Lordship, before I make my submission, lordship, I would like to take my lordships to page 169. Page 169, your lordship.
Prayer portion.
Prayer portion, your lordship. Now, this is the prayer made by the petitioner in the writ petition, your lordship. If I may be allowed to read this, your lordship.
Yes.
The first prayer is, quash and set aside, review or reconsider the impugned order dated 5/7/2010 only with regards to the petitioner. That is Annexure 1 of the writ petition issued by the Director, School Education. And prayer number 2, Your Lordship. Direct the respondent authorities to review and refix the date of regularization and seniority, Your Lordship. Regularization and seniority of the petitioner as a graduate teachers with effect from 16/1/2004.
Yes.
Your Lordship, the learned single judge has considered these prayers made by the petitioners and has dismissed the prayer so made, Your Lordship. Before going into the orders of the judgment orders of the learned single judge, Your Lordship, my learned senior friends has already read it out, but I wanted to make a few submissions on those appointment orders as well as the office memorandum. If so, Your Lordship may kindly allow me.
Yes.
Lordship, there is no dispute to the facts that the petitioner was appointed by an order dated 12/3/1993 on an ad hoc basis, Your Lordship, as seen. Now, this ad hoc basis, Your Lordship, as can be seen from the order, it is made against a person who was transferred from Government Middle School Tanhai to Government High School Junlika. So it is made against a transfer, Your Lordship. Now the issue is, Your Lordship, as my learned senior friend have said, that it is made without transfer, not carrying the post, but transfer from one post to another post. Your Lordship, the person who was appointed there by the name Shitri, this fellow is actually a regular employee, and therefore he was transferred from Government Middle School Tanhai to Government High School Junlika. A person who is transferred, Your Lordship, doesn't mean that he is transferred from one post to another post, doesn't mean that he is carrying the post. But a person who holds that post and got transferred, Your Lordship, if a person is appointed against that post, as to what the submission has been made, Your Lordship, what will happen is that against that particular post, two persons is appointed in that case, Your Lordship. And therefore, the appointment of the petitioner is purely on a ad hoc basis on the stopgap measures. It is not appointed against the sanctioned post, Your Lordship. It is not appointed against the sanctioned post. And therefore, Your Lordship, when it is not made appointment against a sanctioned post, then the office memorandum that was issued by the state respondent with respects to regularizations of the ad hoc and contract employees who have completed 10 years and 5 years. Can that be applied, Your Lordship, as far as the petitioners is concerned? Your Lordship, since the documents are in sequence, if my Lord may be allowed to refer the documents as per the annexure that has been there in the writ petition, Your Lordship. Lordship,
66.
Yes. Lordship, office memorandum 18th.
Oh, you go to the memorandum.
Your Lordship,
81.
Yes. Or shall I read the appointment order, Your Lordship?
See, what about this scale of pay?
Lordship?
Day in, day out, people are coming for scale of pay.
Yes.
Filing writ petitions.
Yes. Yes.
But here is a person
Yes.
who's just appointed on ad hoc basis.
Correct, correct.
Temporarily, according
Yes.
to you.
Yes.
But he's given scale of pay.
Lordship, there are certain, not certain, but many work charge employees also who are not appointed against any substantive post, yet they are granted scale of pay, Your Lordship.
Why?
Because, Your Lordship, the work charge, ad hoc, casuals, all these employees are actually their service are regulated by the Work Charge Commission Act 2001. And their payment, Your Lordship, is also regulated by that. And therefore, since the commission has recommended for scale of pay, Your Lordship, so certain
which commission?
Work Charge and Casual Commission Act 2001, Your Lordship. Nagaland Work Charge and Casual Commission Act 2001.
It provides for scale of pay.
Lordship, the scale of the salary under the work charge and casual employees are regulated by that commission. And since the commission has recommended for scale of pay, and therefore, Your Lordship, they are paid the scale of pay of 1993, Your Lordship. And it is existing till today, Your Lordship. However, Your Lordship, as far as this case is concerned,
Okay.
Lordship, he was appointed substantively on ad hoc basis against the transferred order of one NT Chituri, as I have submitted, Your Lordship. And Your Lordship will find the appointment order on at page 172. I'm going on sequence, Your Lordship, since the documents are arranged in sequence in the writ petition, Your Lordship.
Yes.
The petitioner has arranged it in sequence, so I'll go here, Your Lordship.
Yes.
Page 172, annexure A.
173, you read that is.
Yeah, yes, Your Lordship. 173 is the type copy, Your Lordship. My learned senior friends has already read it out, but Your Lordship, if Your Lordship desires, so I can read it out again, Your Lordship.
Not required.
Okay, Your Lordship. Then, Your Lordship, what happened after this is the office memorandum, 18th February
Lordship, sorry
2004.
for intervention. Kindly, I failed to point out at 173, the endorsement. Lordship, in the appointment order, copy to Lordship, you kindly see. Merit.
Yes.
Copy to the Inspector of Schools Mon. 2, the Deputy of Inspector of Schools for Mon, information in necessary action. He is requested to conduct the interview observing all portal formalities for regular recruitment in submit report. 3, Rakesh Ranjan. It shows that it is a regular appointment. Sorry, I did not point out it in the morning. The 3 conditions.
Lordship. Lordship, in that case, Your Lordship, one para in the order, the third para, no deduction towards GPF fund and group insurance scheme should be made. Your Lordship, only the regular cadets are deducted GPF.
Okay.
So this also shows that it is on ad hoc appointment, Your Lordship.
Then come to the next page.
Lordship.
Which month is this? June.
June 1993, Your Lordship.
Appointment was what? March.
March 1993.
3 months down the line, you give them increment,
Yes, Your Lordship.
including the petitioner.
Yes.
For ad hoc appointment, this is natural.
Your Lordship, because the petitioner has by then cleared B.Ed course.
Okay.
It's clearly mentioned, Your Lordship, consequent upon passing B.Ed. If I may be allowed to read the order, Your Lordship. Type copy is on the next page, Your Lordship. Consequent upon passing B.Ed teachers under the establishment of Deputy Inspector of School Mon is hereby granted 2 increment with effect from the month in which the result is declared. So it is because that they have cleared the B.Ed.
Petition number 3, result was declared in 91. Lordship, serial number 3 at 174.
But it is on the account of because he has cleared his B.Ed. It's clearly mentioned in the order, consequent upon passing B.Ed.
Then the passing is there.
Your Lordship, under the establishment of Deputy Inspector of School is hereby granted 2 increments with effect from the month on which the result is declared. So he was granted that, Your Lordship. Now, Your Lordship, I would like to take my Lordship to the office memorandum at page 178. Page 178, Your Lordship.
Yes.
Now, this office memorandum, it's about regulations of contract and ad hoc appointment, Your Lordship. The petitioner is making a contention that he falls under category 1. Lordship, if I may be allowed to read this category 1.
Yes.
Category 1, ad hoc or contract appointment made against sanctioned post, Your Lordship. So any contract or ad hoc appointment which has been made against the sanctioned post, then, Your Lordship, employees and an employee having more than 10 years of service, and employees in this category, Your Lordship, which category? A category who has been an ad hoc or contract appointment made against a sanctioned post. This is the category, Your Lordship. May be considered for regularization provided that there is a sanctioned post. 2, the petitioner fulfills the eligibility criteria for the post, including the requisite educational qualifications. And 3, the performance of the employee has been satisfactory in the service. So this category, Your Lordship, category 1, clearly meant for those contract or ad hoc appointment which has been made against a sanctioned post. As has been stated, Your Lordship, the petitioner has appointment is not against a sanctioned post. It was against a transfer, Your Lordship. And therefore, Your Lordship, the learned single judge has correctly stated that a person who has been transferred from one post to another post on the same cadre holds the lien of that particular post from which he has been transferred. Having been promoted, Your Lordship, the post would have been relinquished. But transfer, Your Lordship, transfer. Your Lordship, I have been transferred out. Somebody appointed as a stopgap measure, Your Lordship. Can we say that the person is appointed against the post that I hold? If that is the case, Your Lordship, against the post that I hold, 2 appointments is made. The first appointment is mine. And the second appointment is that ad hoc appointment, which has been appointed as a stopgap measure on account of my transfer, Your Lordship. And therefore, the appointment of the petitioner is not made against any sanctioned post. And therefore, this office memorandum, Your Lordship, category 1, or any of the category, Your Lordship, as far as this office memorandum is concerned, cannot be applied, Your Lordship.
So what has been applied
Your Lordship, later on, because the cabinet have decided to regularize the service of the petitioner, including 17 others, Let us
come to that decision. Where is that?
Your Lordship.
According to you, the petitioner doesn't qualify.
No.
To be considered under this provision.
Under these provisions, no, Your Lordship.
But later on, he was regularized.
Yes, yes.
How?
On the decisions of the cabinet, Your Lordship, page 191. Page 191, my Lord. Page 191, Your Lordship. May I read, my Lord?
191.
191, my Lord.
It's not there.
No. Must be there. Page 191.
Oh, sorry. Yes.
May I read this, my Lord?
Yes.
In order dated 5th July 2010, in pursuance of the government approval order dated 15/6/2010, the service of 18 teachers listed in Annexure A who have completed 10 years of continuous service as on 16/1/2004 are hereby regularized under the following terms and conditions. The effective date for regularization will be effect from the date of cabinet approval, that is 18th May 2010. The past service rendered will be counted from all other benefits such as increment, leave, pensions, etc. Lordship C, the inter-se seniority will be fixed in order of the date of joining the post as graduate teacher. So the effective date of regularization is given as 18th of May, 18/5/2010, which is the date where the cabinet gave its approval, Your Lordship.
What was the criteria for the cabinet to give the approval?
Your Lordship, as far as the criteria is concerned, Your Lordship, we have not stated anything as such in our affidavit in opposition.
No, you have to, because you are treating this petitioner separately.
Yes.
There was one category or 2 categories of teachers who
Yes.
were covered by that office member.
Correct. I will explain that, my Lord.
Petitioner is not covered by that.
No.
Because he was never appointed under the sanction.
Correct, my Lord.
Now, but later on,
Yes.
despite that,
Yes.
he was regularized by
Yes.
this order.
Yes.
On the strength of cabinet approval.
Yes.
So what transpired? What led the cabinet to decide to regularize them?
Your Lordship,
What was the criteria?
Your Lordship, maybe because Your Lordship, the services of the ad hoc or contract appointment. There are certain conditions where the government can regularize their service. However, Your Lordship,
Sure.
Just, category, please come back to 81. Sorry, 81 and 81 is all the same memorandum, office memorandum.
Yes.
So here in category 1, you have pointed out this ad hoc contract appointment made against sanction post.
Yes.
This, according to you, is applicable to A, category 1, A,
Yes.
and it should equally be applicable to the B also, C also.
Yes.
It was not.
It should apply.
It did not. It did not. It did not.
It should apply.
Because the condition here is that there is a sanction post.
Yes.
10 years of service, employment having more than 10 years of service,
Yes.
an employee in category may be considered for regularization,
Yes.
provided there is a sanction post.
Yes.
Provided there is a sanction post at that point of time.
Yes. Yes.
So what we could understand, I could understand it at
Yes.
least.
Yes.
So probably this is because it was not applied to B and C for made against sanction post.
No, it will apply, Your Lordship. It will apply.
No, it says employee having 5 to 10 years of service.
Your Lordship,
An
if
employee less than-
no, Your Lordship, if you read it properly, category 1 ad hoc contract appointment made against sanction post A, within bracket A, employees having more than 10 years of service.
Yes.
B, employees having 5 to 10 years of service.
What I meant to say is subsequently the service of others have been regularized. Whether all the persons who have been regularized were
Yes.
against the sanction.
Yes, yes, correct, Your Lordship.
Even the 5 to 10 years. Also.
Yes, yes, Your Lordship. That is what we have mentioned in our affidavit in opposition.
What it says that condition 1, A1, if there is a sanction post, and if he had, sir.
Your Lordship, the 183 teachers who were appointed, they were appointed against a sanction post. Ad hoc, all of them were ad hoc appointees, but they were appointed against a sanction post, and therefore their service was regularized by basing on this office memorandum. And because this office memorandum says that the cabinet has given its approval on 16/1/2004, their effective date of regularization was given as 16/1/2004.
So that means all the regularized.
Yes.
The person whom, as per this memorandum has been regularized, they all were made against the sanction post only.
Yes, Your Lordship.
Except the petitioner.
Except this present petitioner, Your Lordship. Even otherwise, Your Lordship. Is the petitioner challenging those 183 teachers' appointment? No.
But nowhere in the appointment, it is, because subsequently, as my lord has pointed out, that subsequently in the 2010, what was the criteria? So this sanction post was not again the criteria.
Yes, yes, Your Lordship.
So why it was made?
No, that is why, Your Lordship, in affidavit, we have stated that after the vacancy has arose, we have adjusted the petitioners there in those vacancies. That is what we have stated that.
In the appointment of others also, nowhere it is pointed out it is against the sanction. They were appointed against the sanction post, and that has been regularized. Nowhere it is mentioned.
That is not under challenge, Your Lordship, by the petitioner in the writ petition. They have not challenged that. Had that been challenged, probably we would have stated that. 183 teachers, Your Lordship, the petitioner was left out from that 183 teachers. The petition is not grievance by that at all. And therefore, the petitioner have not submitted any representation or have challenged that.
But even if he was not appointed against the sanction post, but then as per this category 1A, then an employee is in this category may be considered for regularization, provided there is a sanction post. And it appears that at that point of time, there was a sanction post.
Lordship, there may be a sanction post, there may not be a sanction post. That is not under challenge by the petitioner in the writ petition. That is what I'm saying, Your Lordship. There may be, there may not be. But that was not the issue raised by the petitioner in the writ petition. The petitioner is not aggrieved at all by the regularization of these 183 teachers. And therefore, we did not went there and then file our affidavit on that line, Your Lordship.
conditions were quite strict in 2004.
Correct, my lord.
What made them to relax everything in 2010?
Yes. Your lordship, that is, in the present writ appeal, it is difficult for me to explain that, your lordship. Because,
No, it doesn't even talk about any sort of screening and all that. That's nothing. If you come to page 191,
yes, yes,
it simply says that these are the 18 persons,
yes,
regularize them.
correct, correct, your lordship.
And it will be from 18 May 2010, because that is the date on which cabinet decided.
Correct, your lordship.
That much only.
Yes, now your lordship, this is the issue now. When the petitioner service regularization date was given on 18 May of 2010, 18 May 2010, petitioner has kept quiet on this.
Oh, that will come to that.
Yes, your lordship. That is why I'm saying, your lordship.
No, we are still in that issue regarding what made them give such kind of concession to these 18 teachers.
Yes,
Because
including the petitioner.
Things were quite tough at
Yes.
the relevant time in 2004.
Yes,
Because you need to be appointed against a sanction post.
yes,
There should be a sanction post available and you have to be screened and recommended by the department.
lordship. Correct, your lordship.
So, but all these things have been relaxed in 2010. Why suddenly? all
Yes,
this-
relax for the benefit of the petitioner, your lordship. So if this is illegal, it can be questioned, set aside, your
So
lordship.
he should be happy about that. isn't he?
Yes, your lordship. Otherwise, it can be questioned, set aside, your lordship. Otherwise, it is on the benefit
Condition is
of the
10 years
petitioner.
of- 10 years of continuous service as on 16/1/2004, who had completed 10 years of continuous service. So it's relating back to 2004, the conditions.
Yeah, your lordship. However, the effective date, your lordship, is very clear. Effective date of regularization will be effect from the date of cabinet approval. That is 18th of May
So
2010.
number one, we don't know what is the cabinet approval. Number two is the reference of 2004 is there. In the cabinet approval of 2004,
Yes,
there were 2-3 trials of dates, effective dates, earlier this date, then that
Yes.
date. Ultimately, they stuck to this 16/1/2004.
correct, man, correct.
So this subsequent cabinet decision of 18 May 2010
Yes,
also travels back again to 2004.
correct,
So
correct.
that thing was still in their mind.
Yes. However, the effective date was given as 18th of May 2010.
Why this special date? Because cabinet decided,
Cabinet decided on this date.
although they want to refer to 2004.
Yes, yes. Now, if it is wrong, your lordship, the petitioner should have then challenged this particular date. But the petitioner have not challenged it, meaning thereby he have accepted this date.
That will be the second limb of your argument,
Yes, my lord.
delay and all that.
Yes, your lordship. No, because that is the ground. Because the prayer made, your lordship, the prayer made is as such that if the prayers is considered, your lordship, my learned senior friend has been stating that no rights of the third parties will be affected. Why I'm bringing this date is, your lordship, if the prayers of the petitioner is actually allowed, many rights of the other parties, third parties, will be affected, your lordship. And the letter single judge has rightly went there, your lordship, and passed the order. Shall I continue, my lord?
Surely.
Lordship.
You want the judgment right away.
No, your lordship.
We'll listen to you, then we'll try to analyze that and maybe
No, your lordship,
the subsequent dates will.
the way your lordship was looking at me, it was it was a little bit intimidating. So I wanted to take the permission of the court before I proceed, my lord.
He has his apprehensions, whether he's been able to convince the court.
Correct, my lord. Correct. I'm doubting myself now, my lord.
So I think I should not give any expression.
Thank you for relaxing me, your lordship.
Okay.
Now, your lordship, as far as the MSCP part is concerned, your lordship, I'd like to make my MS submission at the final stage, your lordship.
Okay.
Thereafter, your lordship, a seniority list was published, your lordship. Your Lordship will find the seniority list starting from page number 205. 205. Now, Your Lordship will find the name of the petitioner.
900 something, isn't it?
970, my lord.
970, yes.
At page 237, my lord. Page 237.
Yes.
And the name of the petitioner reflects at 970. Your Lordship, if you see the column wise, I would like to take my Lordship to last two columns. That is date of regularization and effective date of seniority. Lordship, the petitioner's date of regularization is 18/5/2010. This is the effective date given to him, Your Lordship. And also the date of seniority is 18/5/2010.
This is on the basis of that document.
Yes, on the basis of the regularization, Your Lordship.
Yes. That 191.
Yes, correct, my lord. Now, Your Lordship, what was the prayer made, Your Lordship, to refix his seniority on the basis of that 16/1/2004? Your Lordship, now if his seniority is to be refixed, that means this seniority number has to be changed, and this is the representation of the petitioner. Your Lordship, allow me to take the representation of the petitioner, which is at page 241, on the next page, my lord. Page 241.
241.
241.
Yes.
Kindly allow me to read this, my lord.
First was 2010.
Yes, Your
This is the
Lordship.
second one.
Yes, this is the second one. Your
After
Lordship.
12 years.
After 12 years. Now, Your Lordship, look what he's seeking here, Your Lordship. Subject, calling attention to an official error in my effective date of seniority. Sir, with due respect, I beg to state that I am Rakesh Ranjan, science graduate teacher at Government High School, Ponchim, Mon. I want to bring in your kind notice to an official errors in my effective date of seniority. My current serial number in the interstate seniority list stands at 970. He is referring to this list, my lord.
Yes.
Which is being counted from the date of my service regularization, that is May 2010. Although I would like to highlight the terms and conditions in my service regularization list where it was clearly mentioned to fix interstate seniority in order of the date of joining the post as graduate teacher, which in my case is 12/3/1993. To emphasize, I was already BA degree holders on the date of joining, Your Lordship. So he wants to refix the seniority. And this is exactly the prayer made by the petitioner in the writ petition.
So going by that claim.
Yes. The petitioner will come to.
Will come to 489.
Yes, correct, Your Lordship. He'll have to come to 489. So, Your Lordship, from 489, to 969, Your Lordship. These people will be affected.
All right.
So the question of affecting the third parties arises because of this, Your Lordship. And therefore the prayers cannot be considered, Your Lordship. Lordship. Now, Your Lordship, as with regards to the second representation. This representation, second representation was made on 11/10/2022. That is after accepting the regularization order, he has submitted his representation stating that he should be regularized His regularization seniority should be counted from 12/3/1993. Your Lordship, the second representation is at page 242. 242, Your Lordship. May I read this, my lord?
Yes.
Subject, calling once again for your attention for corrections of official errors in my effective date of seniority and promotion of junior thereafter. On the subject mentioned above, I have the honor to put forth a few lines for your necessary consideration. Action, please. That say it is brought to apprise your knowledge that I3 such and such Mount appointed as graduate teachers on 12 March 1993. One, that's due to official error, my regularization was delayed, Your Lordship, to May 2010, which was supposed to be 26/10/2006, as per the government approval order. Letter such and such, who have completed 10 years of continuous service as on 16/1/2004, in spite of submissions of relevant required documents for regularization process. Two, I was regularized on 18 May, Your Lordship, and which was supposed to be effective date of regularization of my service may be read as 16/1/2004 instead of 18th May 2010, as per the order such and such, a like regularization order of 183 graduate teachers with effect from 26 October 2006 by a government order such and such. Three, that's according to my regularization order clause C, it is clearly mentioned that the interstate seniority will be fixed in order of the date of joining to the post as graduate teachers, unlike above mentioned order. In the seniority list, my name was written as serial number 970, which was supposed to be 489. He is also claiming, Your Lordship, that his seniority should be 489 as per the seniority of joining or appointment.
And we took all the trouble to calculate, no?
Yes, Your Lordship.
He has already calculated.
He has already calculated it. And now he's saying it's not, the third party will not be affected. He himself is claiming, Your Lordship, that once it is adjusted, his number will be 489 instead of 970. Then, Your Lordship, 4. That's right, during finalization of seniority list for promotion in the month of September, October 2022, I have submitted applications dated 10th October 2022 for correction of my serial number bearing 970 in the seniority list. Also, the same application was submitted to Under Secretary School Education, that in spite of the submission application for correction of seniority list, rather, I also got setback as many juniors of me got promoted. No, my name was corrected in the list for your reference. So many junior teachers were given promotion, and some of the names are as follows. Your Lordship, here, the juniors given promotion or getting promotion, Your Lordship, I wanted to make one submission here. If the petitioner was already aware that his juniors were promoted, that means his right has been affected, according to him. Where in the writ petition has the petitioner been able to show or project that he has ventilated his grievance at that point of time when his juniors was promoted, besides just asking the seniority to be rectified? He has not ventilated any of such grievances, Your Lordship, that his juniors has been promoted, just that his seniority has to be refixed. And therefore, the submission so made now in the writ appeal, stating that his juniors has been promoted, Your Lordship, cannot be considered. If that was the case, Your Lordship, he should have projected it. Or he should have come before this honorable court, Your Lordship, ventilating his grievance. He did not do that, Your Lordship. So at this later stage in an appeal petition, Your Lordship, this prayer or such submission cannot be considered, Your Lordship.
Yes.
Now, Your Lordship, as far as the delay in ledger's part is concerned, Your Lordship, the petitioner regularization, Your Lordship, was issued by order dated July 5, 2010.
Yes.
Your Lordship, the petitioner has annexed one representation, which is at page 264, where a prayer for seniority was made. Page 264, Your Lordship, the type copy is at page 265. If I may be allowed to read this, Your Lordship.
Yes.
Subject, prayer for seniority as science graduate teacher. Sir, I have the humble submission to lay before you the following few lines for favor of your kind informations and needful action, please. That, sir, I've been serving as a graduate science teacher past since 1993. All relevant documents in support of my qualification is enclosed as follows. My qualification is MSc B.Ed. Therefore, you are fervently requested to look into the matter as above and needful action for favoring my appeal. Your Lordship, where has he ventilated his grievances as far as with regards to the order dated 5/5/2010, making his effective date of regularization as 18th May 2010 is concerned? If this is the representation which has been submitted against this order, Your Lordship, as stated by the petitioner, Your Lordship, where has they even make a whisper of this particular order, Your Lordship? It is just that from among the category of the graduate science teacher, he is seeking seniority. Because the subject clearly says that prayer for seniority as graduate science graduate teacher. So this cannot be a representation against the order dated 5/7/2010. If any representation could be considered as a representation against this order 5/7/2010, it could be, Your Lordship, it could possibly be the representation 11/10/2022. It could possibly be this, Your Lordship. And when has he ventilated his grievances, Your Lordship? On 11/10/2022, that is after a gap of more than 12 years. 5/7/2010 was the order.
So whether have you disposed of this representation 15/9/2010? Because this was what have you understood, what the department have understood and how they have disposed of this representation.
Lordship, subsequently, in continuation to this representation.
Because ultimately what he is asking for is seniority.
Yes. So in continuation.
He may not be, of course, expert in.
Correct.
Legally expert.
Correct.
But then he has prayed for placing his seniority in his own place.
Correct.
It appears.
Correct. Subsequently, in continuation of this representation, he has submitted another representation dated 23, Your Lordship, which was forwarded to the government and it subsequently got disposed of, rejecting the prayer made by the petitioner. And now, Your Lordship, in this 12 years gate.
Disposed of by which order?
Lordship, it is disposed of by the order dated 6th of October 2023 at page 278. May I read this, my lord?
Yes.
Subject, matters relating to seniority list of graduate teachers under elementary and secondary cadets. Sir, I am directed to refer to a letter number such and such dated 24/2023 and the representation submitted by Sri Melissa AHM and 5 others recently promoted on the subject cited above and to state that government standing rules are followed in regularization and preparations of seniority list, which is applicable to all employees under DOSE. The same may be communicated to the applicants.
The next para is.
Lordship. Further, you are requested to furnish detail as to why representations were left out in the proposal by considerations for promotion in the first phase. Now, Your Lordship, the petitioner in his representation
Which one? 23?
Yes, Your Lordship, at page 242. As he has been
Yes.
para 5, Your Lordship, he has been stating that in between, Your Lordship, his juniors were promoted. Now, as I've stated, Your Lordship, as I've stated, he took more than 12 years to represent to the government with regards to his seniority. And in the meantime, Your Lordship, the seniority list was out because of promotion already cast to some other graduate, to some other teachers, which is why he's stating in his representation that his juniors have already superseded him. Then, Your Lordship, this representation itself clearly shows that there was a delay in submitting the representation. And alleges as well for the fact that the petitioner knows it. If this is to be considered, yet he kept quiet. And therefore, the delay in lectures also, Your Lordship, was considered by the learned single judge while dismissing this the writ petition, Your Lordship. Your Lordship may kindly allow me to read the relevant para of the judgment and order passed by the learned single judge, Your Lordship.
By the way, promotion is to which post?
Assistant headmaster.
Assistant headmaster, Your Lordship.
Just named 5 persons have been promoted to assistant headmaster.
Yes.
Okay. He has referred these names because they were promoted. I mean, they were appointed in the year 1993.
Yes.
He also says that even those who are appointed in 94 have been promoted.
Yes. But he has not ventilated that at all, Your Lordship. At that point, relevant point of time, if at all this is to be considered.
After seeing the promotion, he started writing this letter.
Correct, my lord.
So,
Now, Your Lordship.
You wanted to read the judgment?
Yes, with the judgment. Your Lordship, page 55, para 22. This is with regards to the employment, Your Lordship. The learned single judge has defined this. If I may be allowed to read this, Your Lordship.
Yes.
This court further finds it relevant to observe that transfer in relation to a service simply means a change of place of employment within an organization. Such transfer being to a similar post in the same cadres, and therefore, obviously, such a transfer does not result in the terminations of the lien in the parent cadres. But on the other hand, a recruitment by transfer is a totally different concept in as much as it is a method of recruitment to a service. Once an employee undergoes a transfer by way of recruitment to a different cadres or to a different service, the employee loses his or her liens in the parent cadres or services. In that process, there is an induction to a new cadres. Such induction has the distinct consequences on the careers of the employees different from what would have been the normal course that had he continued in the parent service. Therefore, a recruitment by transfer terminates the lien of an employee in a parent cadres service, whereas transfer simply cites to a similar post in the same cadres results only in the change of place of employment, and therefore there is no terminations of the lien. Your Lordship, para 23. On the next page, Your Lordship. May I read this, my lord?
Yes.
In the backdrop of the above, this court finds it relevant to take note of that lien. That lien is not a word of art. It connotes the right of a civil servant to hold the post substantively to which he or she is appointed, or in other words, the lien of a government employee in service law is a right of a government employee to hold a permanent post substantively to which he has been permanently appointed, Your Lordship. Then, para 24. In the backdrop of the above, if this court take notes of the order dated 12/3/1993, this is the appointment order, Your Lordship, enclosed in Annexure A to the writ petition, it would be seen that Sri N.T. Shitri was merely transferred to a government high school, Chumlika. Therefore, Sri N.T. Shitri continues to hold his lien over the post substantively to which he was appointed. The logical corollary, therefore, would be that till Sri N.T. Shitri was not promoted or transferred to other cadres, he continued to hold the lien of the post to which the petitioner was appointed as a stopgap arrangement. Under such circumstances, it cannot be said that the appointment of the petitioner on a ad hoc basis was to a vacant sanctioned post. The consequential effect, therefore, would be that the petitioner would not come within the ambit of the employees of category 1 of the office memorandum dated 18/2/2004. This is with regards to the ad hoc appointment, sanctioned post, as well as the office memorandum, Your Lordship. Lordship, para 25.
Yes.
The second point for determinations pertain as to whether the petitioners would be entitled to his seniority from the date of his appointment, that is 12/3/1993, in terms with the order dated 5/7/2010, or his seniority is to be calculated with effect from the date of his regularization stipulated in the order dated 5/7/2010, that is 18/5/2010. The entire edifice on which the petitioners claim his seniority is on clause C, Your Lordship, of the order dated 5/7/2010, which stipulates that the inter se seniority would be fixed in the order of the date of joining the post as graduate teacher. This is clause C, Your Lordship. It is, however, relevant to take note that as per clause A, the effective date of regularization was held to be with effect from 18/5/2010. It is also relevant to take note of the said order dated 5/7/2010 has also to be read along with annexure A to the said order whereby 18%, including the petitioners, were regularized. The inter se seniority, therefore, as mentioned in the order dated 5/7/2010, in the opinion of this court, has to be in relation to the inter se seniority amongst the 18% who were regularized as per annexure A to the order dated 5/7/2010. It is also the opinion of this court that if any other interpretation given to the order dated 5/7/2010 will violate the very concept of regularization. Lordship, para 27. Page 59, my lord. In view of the above propositions of law, it would be seen that as the petitioner herein along with 17 others were regularized with effect from 18/5/2010, that is the date of the decision taken by the cabinet. Therefore, the said date has to be taken as the date on which the petitioner has entered into the service of education, cadres of government of Nagaland, and consequently, the interstate seniority as stipulated in clause C of the order dated 5/7/2010 has to be read as an interstate seniority amongst the 18 persons, including the petitioner, who were regularized by the order dated 5/7/2010. Therefore, in the opinion of this court, the cushions of the petitioner being entitled to have interstate seniority as on date of his contractual appointment, that is 12/3/1993, is totally misconceived. Your Lordship. Para 29, my lord.
Perhaps what you want to say or what it means is that the effective date of the regularization is 18/5/2010.
Correct.
Amongst 5, 10, 18 persons who are regularized on that,
Along with the petitioner.
no, those who are regularized on
Yes.
that date,
Yes.
their seniority will be determined from the date of their initial appointment.
No, the seniority will be determined for.
Amongst those 18 persons.
Yes.
Not those who have been appointed earlier,
Yes, correct, my lord.
isn't it?
Correct, my lord.
Otherwise, why there should be an effective date?
Yes, your lordship.
This is the effective date. All of you are appointed with effect from this date.
Yes.
But when it comes to seniority, seniority will be drawn from the date of initial appointment
Seniority will be drawn from the date they join as a graduate teacher.
amongst those 18
Yes,
persons.
yes, your lordship.
Okay, so
Para 29, my lord.
delay latches.
Yes, your lordship.
Mr. Takamasa has dealt with this. Is
Yes,
shown
Your
us Tarsem
Okay.
Singh also.
Yes, then in that case, your lordship, para 31, page 63, my lord. May I read this, my lord?
Yes.
Applying the above principles as laid down by the Supreme Court and taking into account the facts involved, it would be clearly seen that the petitioner neither challenged the action of the respondent authorities in not regularizing the case of the petitioner in the year 2006, along with 183 other teachers, nor assailed the order dated 5/7/2010, when he was regularized, and the petitioner did not take any step pursuant to 15/9/2010, when he submitted the representations and thereupon slept for more than 12 years over the issue of seniority. This court also finds it relevant to take note of the present case. If any relief is granted, it would definitely affect the person who are above the petitioner in the interstate seniority list. In the present case, in the present cleverly drafted writ petition, though no relief has been sought challenging the various promotion orders made to those persons who are senior in the interstate seniority list, but any writ issued granting the relief herein would definitely affect those persons who are above in the seniority list. This is what your lordship I've been projecting. Persons who are above him will definitely be affected. And therefore, in our affidavit in opposition, we have also taken the ground that those persons should be implemented then in that case. But because they were not implemented, the petition deserved to be dismissed on the ground of non-joiners of necessary parties. We took that ground, your lordship. Para 32, my lord. Consequently, in the opinion of this court, as the petitioner has slept over his right for more than 17 years in respect of his first course of action, which arose in the year 2006, when 183 teachers with whom the petitioners claim parity were regularized, and 13 years from the date of the petitioner's claim to be aggrieved on account of his regularization, given effect to from 18/5/2010. It is the opinion of this court that the writ petition suffers from delay and latches, for which the writ petitions is required to be dismissed on this ground also. There is nothing wrong, your lordship, in the judgment and order passed by the learned single judge, your lordship. The learned single judge has dealt deep into the prayers made by petitioners in the writ petitions and found that, the Lordship, if his prayers is answered, the third parties will be affected, which the petitioners have not made them a party in the writ petition. Number two, it attracts delay and latches for the fact that if at all he has a grievance, he should have ventilated his grievances 12 years back. He did not. He accepted it. He accepted it only after a gap of 12 years, when his seniority was shown as 970. He approached the department stating that his seniority should not be there, but it should be counted with effect from 16/1/2004. By then, Your Lordship, as submitted by him, by then, some people who are junior to him have already been promoted. And that also, Your Lordship, the petitioner have not ventilated his grievances at all. There is not only delay, but latches on the part of the petitioners as well, Your Lordship. And therefore, Your Lordship, my humble submission is there's nothing wrong in the order passed by the learned single judge. And therefore, this writ petition deserves to be dismissed, my lord. I'm deeply obliged.
Lordship, I'll take 2 minutes. I'll only clarify 2 grounds. I'll not take much time. Lordship, on the issue of substantive appointment and service lien, issue has been raised. In my respectful submission, my lord, the issue of lien is misplaced in the present case because the issue of lien will not come into play. My lord, the appointment orders, initial appointment orders, the learned single judge has failed to take into consideration the condition which we have read. That, my lord, the incumbent, my lord, that the deputy inspector, to necessary action, he is requested to conduct the interview, observing all court formalities for regular recruitment and submit report. So the deputy inspector of school petitioner was appointed, and his vacancy, page 66 condition, his vacancy is to be filled out through regular appointment. That is the condition given.
But where is the follow-up?
My lord, in the meantime, no action, no follow-up was there, but in the meantime, the regularization came into play, my lord. Yes, the deputy inspector of school did not conduct interview, but the fact remains that it's a regular vacancy is proved by the fact that at page 66 condition, deputy inspector of school was directed to conduct an interview for the vacancy. It proves that it is a sanctioned post. My lord, condition number 2, 66, copy 2.
Yes, I've seen.
So that is one. So, my lord, unfortunately, the learned single judge failed to take into consideration that condition, which shows that he is appointed, conduct interview. If it is not a substantive vacancy, how can a direction be given for interview? In those days, it was the deputy inspector of school who conduct interviews. 1. My lord, on the issue of service lien. My lord, when a person is appointed on regular basis, he holds a lien to the post, he is appointed, fine. But my lord, when a person is transferred one place to another place, there are 100 vacancies, substantive vacancies. One person is transferred from one person place to another. Just because he is transferred one place to another does not mean he carries the post from one place to another. Lordship is well aware. In a transfer post, once somebody is transferred out, vacancy arises, a person is appointed against that vacancy. That's why interview was conducted. So the learned single judge going into a lien in my respectful submission have no relevance in the present case. Now my learned friend has given strong reliance on my representations. 3 representations, that's in submitted that representation has not been properly drafted. Then there is a 12 years delay from the first representation to the second representation, and the contents of the representation, so on and so forth. In the morning, Lordship, I made a fair submission that after my representations was submitted, had the respondent simply ignored it or rejected my representation on the ground of delay in lashes, I wouldn't have approached this honorable court. That's what I said in the morning. But I was given a new lease of life by the 20th April 2023 letter at page 277, when the principal director, my lord, considered my case and forwarded for consideration. If not for this letter, I won't be here before this honorable court. That is the issue, Lordship. Thereafter, My lord, during the pendency, it was rejected on 6 October 2023 in the affidavit clearly shows. So this aspect of the matter, these two crucial documents, the learned single judge has failed to examine at all. Because
What is that? One is that 23.
my lord, page 277.
Recommendation.
Yes. And my lord, it is self-explanatory.
This and what is the other one?
Then, my lord, the next page, 278. The rejection of my representation during the pendency of the writ petition. And, my lord, when it is rejected, my lord, at 278, it is not rejected on the ground of delay in lashes. Lordship may kindly see the rejection, the grounds given for at 278. If the writ petitions were, if my representations were rejected on the ground by the government on the ground of delay in lashes, then yes, the respondents may have a case. But Lordship, on what grounds we have gone through over and over again these two documents. So, my lord, on what basis my representation was rejected? It simply says that the government guidelines were followed to convey, and the reason why my case was not put up, when my representation was not put up in time. That is what it says. Not lashes and delay. So, my lord, this aspect of the matter, the learned single judge has miserably failed to examine, consider. Thirdly, Lordship, my learned friend has said that I did not challenge the regularization of those similarly situated persons. My lord, it is not necessary to challenge. I have no grievance against the regularization. My only prayer is that I should be treated, because substantive vacancies, sufficient substantive vacancies were available for everyone. So my only prayer before this honorable court is treat me equally like the others. I have no grievance against the regularizations. Because, my lord, I am in no way aggrieved by the regularization. I am only praying for similar treatment. Much obliged, Lordship.
Lordship, with regards to MSCP, I forgot to make a submission with regards to MSCP. I was supposed to submit at the end. MSCP, I did not submit that, Your Lordship.
You may submit.
Yeah, Your Lordship, the MSCP, this actually was wrongly given. For the fact that, Your Lordship, MSCP is counted on, is meant only for the regular government servant. And MSCP, there are 3 leaves under the MSCP scheme. The first leave, second leave, and the third leave. The first leave starts from 10 years after regularization, Your Lordship. So the regularization was effected from, with effect from 18th of May 2010. That means, Your Lordship, it should be on 18th of May 2020. The 10 years will complete. Whereas wrongly, MSCP was given on 16th of September 2014 to the petitioner. Therefore, Your Lordship, we have issued an order asking him to resubmit his.
One MSCP.
Yes, the first leave for MSCP.
Only one has been granted.
Only one has been granted. Only one has been granted.
Is there any such kind of out here, the notification regarding MSCP?
Yes, Your Lordship.
In this document, it is not there.
No, it is not there. It is not there. But
sorry for but my lord, every 10 years.
Yes, every 10 years.
First leave, second leave, third leave.
Yes.
No, that guidelines is not available. Can you produce that?
Guidelines, Your Lordship, yes, yes.
MSCP.
MSCP, Your Lordship, I think I'll be able to. I'll be able to get it, Your Lordship.
Because you are saying that it's only given to regular.
Yes, yes, yes.
Well, I'm not disputing that. I'm not disputing that.
Anyway, we would like to see that.
Lordship, Lordship. Lordship.
You produce and give it to us.
I'm deeply obliged, my lord.
We'll reserve the judgment.
Lordship.
Heard Mr. Takamasa, Lanet Senior Counsel, assisted by Mr.
Aren
Long for the appellant, and Mr. N. Angami, Lanet State Counsel, appearing for all the respondents.
All the respondents, man.
Hearing concluded or reserved.
Deeply obliged, my lord.
For hearing, item number 14.
May bless Lordship. We have only 15 minutes.
So when?
I'll take at least 20 minutes on my part.
We all-
Lordship, I may be hurt in whether we kept buttered for 15 minutes. I'll try to complete my submission.
No, not part hard. We would like to complete. Once we open up, it's better.
Yes. Otherwise, it's a
Because
short.
we are very forgetful, you see, we tend to forget
Yes, Your
everything.
Lordship, we understand.
So,
The issue involved is only regarding the delay. and
Limited
lack
question of law, Lordship.
Yes.
Writ petition was dismissed on the ground that there is a delay on the part of the petition, appellant petitioner and approaching the Red Court. That is the only issue, Lordship. Merit was not discussed. No finding on merit, Lordship. So the only question is whether there is delay in approaching the Red Court. That is the only issue to be decided.
Can we have it again on Wednesday?
Yes, Lordship.
Coming Wednesday?
Your Lordship.
All right. As paid for by the parties, list the matter again for hearing on 28th of August, 2024. All of you have patiently waited for this matter. I wish we could have taken up anyway. We'll see on Wednesday.